that you're giving up those rights?
Yes, sir.
And use of drug paraphernalia is a misdemeanor, which means the maximum penalty is 90 days in jail, $1,000 fine. Theft third is a gross misdemeanor. It means the maximum penalty is 364 days in jail and a $5,000 fine. You understand those are the maximum penalties. I don't have to follow the recommendation that's contained in this agreement. I can sentence you up to the maximum.
Yes, sir.
Okay. Paragraph 11 states, following occurred in the city of Yelm. On August 13th, 2025, I stole merchandise from Walmart. And then on December 13th, 2025, I possessed a pipe that I'd recently used to smoke methamphetamine. Is that your statement, Mr. Morgan?
Yes, sir.
So as to the charge of theft third degree alleged to have occurred on August 13th in the city of Yelm, how do you plead, guilty or not guilty?
Guilty.
And as to the charge of possession of drug paraphernalia alleged to have occurred on December 13th, how do you plead, guilty or not guilty?
Guilty.
Okay, I'll find your pleas are made knowingly and voluntarily. And upon acceptance of those pleas, the city moving to dismiss the controlled substance knowing possession charge? Okay. All right. We'll move to sentencing. I'll hear from the city first.
Your Honor, it's
Okay, Mr. Haverco, anything additional?
Nothing to add. It's agreed recommendation, credit for time served. Anticipate, hopefully, if the court goes along with it, he'll be released today.
Okay. All right, Mr. Morgan, you don't have to say anything. Is there anything you'd like to say before sentencing?
No.
All right. How many days credit does he have?
How long has he been in jail? He's been in jail since the 3rd, Your Honor.
3rd of March?
Yes.
Yeah. Yes.
All right, Mr. Morgan, I'm looking at your record. I don't see an inordinate amount of theft thirds. So I'm going to go ahead and follow the recommendation. I'm going to impose 364 days in jail. I'm going to suspend 354. So I'll give you 10 days credit. Going to impose $5,000 fine. It was suspend all $5,000. Jurisdiction will be for 12 months. On the use of drug paraphernalia, I'm going to impose 90 days in jail. Going to suspend all 90. Impose $1,000 fine. Suspend all $1,000 again for a period of 12 months. So you'll get 10 days credit on the theft third, which still leaves 350 days hanging over your head. Conditions of release will be no criminal law violations, appeared all timely at all court hearings. I'm going to have you not go, obviously not to have any contact with Walmart. Do you understand that?
Yes, sir.
Okay. So when we get that. Okay. All right, Mr. Morgan, I'm going to sign this order and you'll get a copy of it in the jail and you'll be released. Just, understand if you're shoplifting again, we're going to arrest you and take you in. Understood? Okay. All right. Good luck to you.
Thank you.
And on Your Honor, the defendant, Ms. Rivkin, she was on the phone, I think, with counsel. So my understanding is she already has hired counsel or is going to. Okay. So
Yeah,
that concludes my matters, and I will head to the court. Thank you.
All right. Thank you. See you in a minute. All right. And we'll call Natalia Rivkin. Rivkin. Am I pronounce that correctly?
Thank you.
Okay.
Malika Johnson on behalf.
Good morning, Your Honor.
Thank you very much.
All right. Good morning, Ms. Rivkin. This is cause number 680010679. Ms. Rivkin is present in the Nisqually jail. Counsel is present in courts. And you are Malika Johnson? Good morning. And Ms. Johnson, what are we doing with Ms. Rivkin's case today?
Your Honor, I think we're proceeding with the arraignment.
Okay. We'll turn it over to you. Go ahead.
The opportunity to speak before court today. We went over the charge as well as the statement of probable cause. I believe she understands what the nature of the charges are. And we are entering a plea
Okay, stipulated in probable cause purposes, today's hearing only.
for purposes
Okay.
of today. Yes, Your Honor.
All right, Ms. Rivkin, your counsel's indicated, we're going to stipulate the probable cause purposes hearing only. We'll waive any further reading of rights. We're going to enter a plea of not guilty to the one count of DUI under cause number 680010679. It looks like previously conditions were set. We have a pretty high bail. I'll hear from the city as terms of conditions of release.
Your Honor, I briefly spoke with counsel and if on proposed conditions, that would be reducing bail to 5,000 DHM and spring. Was there anything else?
Those are it. Yeah.
Okay. So, Ms. Rivkin, and I'll hear from counsel.
No,
Anything
Your Honor,
additional?
it was an agreed recommendation. Ms. Ripken has been compliant with all court conditions that have been asked of her in the past. I believe this is the appropriate, these are the appropriate conditions, given that the scram device will be the most effective means to ensure that she is dead. There is no history of failures to appear. And she has hired private counsel, and we will be in constant contact.
Okay. All right, Ms. Rivkin, so I'm just going to take a look at something really quickly. So, Ms. Rivkin, you've been in jail since looks like the 9th. What I will do is I'll go ahead and reduce the bail to $5,000 cash or bond. With the additional conditions of you are to have a scram device. Do you have a group, or do you have somebody used for the scram device?
We can put her in contact with someone unless the court has a preferred.
Well, I don't, or the court doesn't. I want her on scram within 24 hours of release.
Okay.
And you're not to operate an intermotor vehicle without ignition interlock. You're not to drive without license and insurance. You're not to consume any alcohol or non-prescribed drugs. You're not to go to a bar or tavern. You are to submit to a test of your breath or blood, and this will all be in the order. This will you are to submit to a test of your breath or blood if asked to do so by probation or the court or law enforcement.
I'm agree to that.
Scram device within 24 hours of release, and also you're not to operate an intermotor vehicle without ignition interlock. Do you understand those conditions?
I understand those.
So, Ms. Johnson, I was looking at her history. So she's got based on my math, she's got a DUI from 2020. She's got a DUI amended to a neg in 2021. A DUI that she's on the deferred for from 2021, and then she's got this DUI. So the dilemma we run into is, depending on what happens with that 2021 deferred, which is still pending, this may get kicked up to felony at some point. So I think the prosecutor's aware of that. So we'll just kind of track this while it's going, but I'll leave that up to the prosecutor's office, just so you know. And I don't know. It may already be a felony, because I'm not sure if a pending deferred counts as a prior under the statute. I just don't know. I haven't looked at that. So, all right, Ms. Rivkin, if you are released, I also want you to be in contact with your lawyer on a weekly basis. And if there's any issues of any compliance whatsoever, your conditions of release will be revoked.
I understand that.
Understand?
Yes. Thank
All
you.
right. Okay.
I do have one question.
Mhm.
Are we permitted to file the bond directly with the court?
No, you go through the jail.
So it's 5,000 for the jail, right?
Yeah, however they do it. We don't take the bond.
You guys don't take any
No.
bonds here? Okay.
Nope. So it'll be through the Nisqually jail. Okay, so we'll need presumably out of custody court date. I wouldn't, but no more than a month out. Let's do the 26th. Let's do March 26th.
Okay.
Thank you, Your Honor.
All right, well, let me give you that court date really quickly.
That will be at 8:30 or?
It'll be at 9 a.m.
9 a.m.?
So next court date is going to be March 26th at 9 a.m. Get a copy of this order, and I've signed the order. Ms. Johnson, you'll pick it up at the window over by the police station.
Great.
Okay,
Thank you very much.
thank you.
Thank you, Your Honor.
All right, thank you. Good luck. All right, let's go back to the 9 o'clock. Do we have any matters ready on the 9 o'clock? Or are we waiting for Mr. Havergal? We have the Holmes matter. Did we discuss, that was Mr. Pelon's case? Are we going to reset that one?
We'll be resetting, but prior to that, we have the matter of
Daniel Schaus.
What's the last name?
Schaus, Schauss.
Oh, there we go. Danielle Schaus, cause number 580-864-572. Ms. Schaus is present out of custody with counsel. What are we doing with Ms. Schaus's case today?
For the record, Your Honor, this is Madeline Denny. I'm covering this hearing for Attorney of Record J. Crone, bar number 64716. And we're ready to enter an SOC in this matter today.
All right. Get to that. All right, Ms. Schaus, were you here earlier when I went over a couple of these agreements with some other folks? Okay. So have you had enough time to go over this with your counsel?
Yes.
All right, you understand the pros and cons of this, you understand the rights you're giving up, you understand the benefits if you are compliant, and you understand the problems if you're not.
I do understand.
Okay. This is going to be a 48-month SOC for a DUI. If successful, this would amend to a neg driving first degree. Costs are $250. Counsel, you feel like your attorney, you feel like your client understands this, has enough time to contemplate this?
Yes, Your Honor. My office has discussed this with her. I touched base with her on this morning. She's had full time to review and ask any questions to counsel. She has already completed her substance use disorder evaluation, and I have a copy here if you would like.
I'll have you file it with the court, so appreciate that. All right. Okay, Ms. Schaus, anything else from the city? All right, Ms. Schaus, good luck to you. I've signed the order. Okay,
Thank you, Your Honor.
thank you. Okay. Anyone else ready to go? So the Holmes matter is, we're just going to be continuing that? Okay, we can wait on that one. And then I have a order to dismiss on Jordan, Sean Jordan. Okay, Mr. Jordan present? Come on forward, Mr. Jordan. Just right there. Yeah. I mean, you can come sit over here if you'd like, but I'm Mr. All right, this is cause number 580-760233. Mr. Sean Michael Jordan is present. Do we have Ms. Lesh, are you here for Mr. Jordan's case?
I am, and good morning, Your Honor.
Good
For the
morning.
record, Celia Lush with Gardner Law for Mr. Jordan, present in person.
All right, and it looks like we've got a proposed order to dismiss without prejudice. I assume no objection to me signing that?
No objection.
Great. I have signed the order. Mr. Jordan, good luck to you, and that will conclude your matter. All pretrial conditions obviously are released and you're free to go. All right. Ms. Lesh, do you have any other matters?
That was my only matter. Thank
Right.
you, Your Honor.
Have a good rest of your day.
You as well.
Oh, and Mr. Jordan, you'll be able to get a copy of that order to your right. Okay. All right. And then I saw a order of dismissal on Romano.
Yes, Your Honor, I don't believe Mr. Crowe is going to be parents, but city moves to dismiss.
Okay. That's on the, which calendar is that on? 9 o'clock, okay. Let's see. I don't even have a file for it. Okay. You know which calendar it is on? Oh, I got you. Okay. Okay, that's perfect. So I'm going to sign the order dismissing cause number 6A0006671 without prejudice on the City of Yelm versus Robert Anthony Romano matter. Okay, sign that order. Do we have anybody? Okay. Is that on the is there Xavier Lindy? Mr. Girl, are you representing Xavier Lindy?
I am here, yes, Your Honor.
Okay, all right. This is cause number 580754693. Mr. Lindy is present out of custody. Again, also we're here on 580700137. So it looks like 2 pending DUI charges. All right, Mr. Girl, what are we doing with Mr. Lindy's case today?
So, Your Honor, I've been in discussions with the prosecutor. At this time, we've not been able to reach a resolution in either matter. We're going to be asking the court to set each of them for motions in trial. I have uploaded pretrial orders in each matter separately. The only thing that I've not put in there are the dates. I don't know that it really matters which one we set first, but what I had expressed to the prosecutor was that if we take one of them and let's say set a 3-6 motion hearing in late April with the readiness and trial in the first half of May, and then take the second one and set the motion hearing in the latter part of May with the readiness and trial date late May, early June, we would be recommencing speedy trial in each case the next time that we're in court. So if I just don't know what the court's calendaring patterns and all of that. And I'll defer to counsel, who I'm sure has a much better idea of how those dates work.
All right, Mr. Radfield, on the Lindy matter, what are your thoughts on the dates?
Oh, the dates Mr. Girl proposed work for the city.
Okay.
Staggering, yeah.
Yeah, what are we doing our bench trial, jury trial?
Jury trial, Your Honor.
Okay, so that'll go to county. So what we'll do, since you're setting it for trial, we'll get that process going with the county. So that'll be transferred, jurisdiction or venue will be transferred over to Thurston County District Court.
Okay.
They'll probably handle all the motions as well. They would, okay. Where are we at with speedy trial? So, Mr. Girl, we have the speedy trial waiver checked on this form. Is that where are we at speedy on this?
Yes. No, we're again, and I apologize just because I just don't know what those dates would look like, but the agreement, and I did discuss this with Mr. Lindy, the agreement would be, for instance, on the case ending in 9/3, whatever motion date was set, we would agree to waive speedy trial and have that also be the new commencement date. And the same thing with the case ending in 3/7.
Okay. Okay, so how do we do this? So
This is a first for me, so I apologize. I didn't know that they transfer jurisdiction.
okay. So we've got plenty of speedy trial.
Yep, it's still June, so we're good on that.
Okay.
I'll just send it over to county.
And then Mr. Girl, what the process is we send this over to county and then
Sure.
you'll get these dates from the county. So we're not going to get dates today.
That's fine. I
Depending on
understand.
those dates, I mean, I guess we could put on this waiver that the new commencement date will be whatever date the motion hearing is.
Sure.
Are you okay if we add that to it?
Yeah, that's fine.
Just in case, because right now speedy trial's through June, I think. So
Yeah.
I want to put under the speedy trial aspect of this, Madam Clerk, be 90 days, obviously. And it'll be on whatever date the commencement, if you can, are you able to put this in? Commencement date will be whatever date the motion hearings are held.
Sure. And just for my future reference, is it the practice of the court that if this was being requested to be a bench trial, that they would maintain jurisdiction here, or?
Stays here if it's bench trial.
Understood. Okay. It's good to know.
So if something changes, let us know.
Will do.
All right. So Mr. Lindy, we're sorry we're talking around you, but what we're doing is trying to figure out procedurally where we are. Okay. So what we're going to do is we're not going to give you dates today because with the request for jury trial, when it gets set for jury trial, the matters get sent over to Thurston County District Court because the city contracts with them to handle all the prerequisites as it relates to a actual setting of a jury trial. So your dates are going to come from Thurston County District Court moving forward, but I'll have you be in touch, obviously, with Mr. Girl about that. Going to have the clerk just sort of, are we able to put that in on the thing? No, it'd be, the county doesn't. County, they go through then we can't put, okay. All right. So, Mr. Girl, we're going to leave leave the speedy trial date kind of open, leave that box checked, but
Sure.
we're not going to be able to put a date for a commencement date. I mean, I guess we could put today, worst case scenario. Are you okay if we put today?
Yes.
Let's just put today, and that gives us through June, which is okay. And then if that's something you need to modify in the future, we can do that. So, all right.
Will do.
Sign this order. And Mr. Lindy, you're going to we'll send a copy to your counsel, but you're going to grab a copy of this order for both cases. It'll be at the window to your right. Okay. Anything else, Mr. Girl, on this matter?
No, Your Honor. I do have another matter, but nothing further on this one.
Okay. All right, Mr. Lindy, good luck to you. Stay in touch with Mr. Girl. Okay. Yep. Okay. What's your other matter, Mr. Is it the Wilson, Michael Wilson?
Yes, Your Honor.
Wilson present? Good morning, Mr. Wilson. All right, this is cause number 5A03-12298. Mr. Wilson is present. Counsel is present via Zoom. What are we doing with Mr. Wilson's case today?
Well, this will be a little more straightforward, Your Honor. In this case, we have reached a resolution. I believe the city has a motion regarding the original charge.
Yes, Your Honor. City's moving to amend breakfast.
Yep, reckless driving. Okay. All right. So you are Michael Ray Wilson, correct? All right, Mr. Wilson. Actually, I'll let you start, Mr. Girl. Do you have a chance to go over this with Mr. Wilson?
I did, Your Honor. We went over everything. I actually was able to download and I sent him a copy of the document. We went over it this morning. We will obviously have no objection to the amendment. We'll waive any further formal arraignment on that, Mr. Wilson. We'll be entering a plea of guilty to the new amended charge. We went over the elements of that offense, what the city would have to prove if it went to trial. We also went over the rights that he is giving up by entering into this plea, all of the rights that are contained in that particular paragraph, as well as the right to appeal. We went over the agreed sentencing recommendation, which calls for a suspended sentence other than 5 days, but an agreed recommendation to Your Honor that he be allowed to serve that on electronic home monitoring. But I also indicated to him that you don't have to follow that. You could impose up to the maximum, which he understands a year in jail and a $5,000 fine. We went over any potential immigration consequences. We also discussed the 30-day license suspension that comes from a reckless driving conviction, as well as in the event that he has a prior within 7 years, this would likely trigger a 6-month ignition interlock requirement. He is making this plea knowing, intelligently, and voluntarily. Nobody's made any threats or promises to get him to do this. I wrote the statement on plea of guilty. I went over that with him. He's prepared to adopt that as his own statement. So with that, Your Honor, I would ask you to allow or to find that he's making this plea knowingly, intelligently, and voluntarily, and that you accept the plea.
All right, thank you. Okay, Mr. Wilson, your attorney did a very good job going over this form. Did he read it to you? Did you read it to yourself or both?
Both.
Okay, all right. You understand the constitutional rights you're giving up? And you understand that this is an amendment, and the city's making a motion to amend?
Yes. it is
Okay.
that.
And you understand I don't have to follow any recommendation. I could technically sentence you up to the maximum, which in this case would be 364 days in jail. Okay. All right. So paragraph 11 states on or about April 19th of 2025 in the city of Yelm, I drove with willful disregard for safety of property by crossing my lanes of travel after consuming liquor. Is that your statement? Okay. So as to the charge of the amended charge of reckless driving, how do you plead, guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea, and I will accept the plea. So now we'll move to sentencing. I'll hear from the city.
Your Honor, it's an agreed recommendation. It's laid out.
Okay. All right, Mr. Girl.
It is an agreed recommendation, Your Honor. I would ask the court to follow it, taking into account that in this case, there was a rather moderate BAC level, I believe, an 09. Mr. Wilson has been engaged in treatment for 6 months. It's a 1-year program. He's been in full compliance. He understands that from this point forward, he'll be required to release that information to the court. You know that this was a pretty exhaustively negotiated case with the city, and I appreciate counsel for the agreement that we're ultimately able to come to. I do think that it's very fair and appropriate, and I would ask you to follow the recommendation.
All right, thank you. All right, Mr. Wilson, this is your opportunity to say something before sentencing. You don't have to say anything if you don't want to, but it's your opportunity. Okay. All right. So I'm looking at Mr. Wilson's history. So Mr. Wilson, you've got a DUI from 2017, and then you have you successfully completed a deferred in 2019. Does that sound about right? And you're looking at a 1-year treatment program now?
I think I'm actually in a 2-year program.
Probably 1 year.
It might be.
It's a 1 year.
Okay. So let me give you a little bit of background. If this was in Lewis County, I can pretty confidently tell you, you'd be looking at 6 months sitting in jail. You understand that? So you're getting the recommendation here is a very good recommendation. What do you do for work?
I work for a composite company makes the carbon fiber film.
Okay, are you going to be able to work while you're on electronic home monitoring?
Yes.
Okay,
As long as the monitoring.
right. Okay. All right. What I'm going to do, Mr. Wilson, is this. I'm going to follow the recommendation generally. I am going to change it in one manner, and I'm going to tell you what and why. And the reason I wanted to ask about what you do is because this. I'm going to follow the recommendation, but I'm going to give you 30 days on electronic home monitoring. Okay. And you can work, but I want this to be an inconvenience at best. And I want you to make sure you understand, even I understand with an 09, it's low. It's still, whether we like it or not, it's a violation of the law as it relates to those numbers. So it is imperative that you learn from this and you listen to everything Mr. Girl told you, because I'm sure he gave you a very similar speech. If you were in different jurisdictions, you would be getting buried. Okay. So I'm going to follow the recommendation. I'm going to give you 30 days electronic home monitoring. How much time do you need to set that up?
Maybe 2 weeks.
Your Honor, just in the abundance of caution, because I'm probably a little more familiar with how these things work and how sometimes there can be obstacles. Would you give him 30 days to get
I'm going to give him 30
hooked up
days.
on? Thank you.
So you're going to get 30 days to set it up. You need to be on it within 30 days from today's date.
Okay.
Okay. And then I don't have any objection. Obviously, private EHM as required. All other conditions in the jurisdiction will be 2 years. Did he, Madam Clerk, did Mr. Wilson, do you have any credit for time served?
I don't.
Okay.
I spent about 8 hours.
So Madam Clerk, just when you, where it's 364, suspend 334? Yeah, that just needs to be changed. Okay. And then probation fee and all the other conditions, complete your treatment, make sure treatment's proofs getting sent in here. And stay in compliance and hopefully we won't see you again. Okay. All right, I'll sign this order. And Mr. Girl, did I miss anything?
I don't believe so, Your Honor. And we will be filing the evaluation enrollment letter. He'll get all of his future compliance reports in, as well as the DUI victims panel. I think we have that done as well.
Great. All right. Okay, Mr. Wilson, good luck to you. And you'll grab a copy of that order at the window. And Mr. Girl, anything else?
No, Your Honor. Thank you. Thank you, counsel.
Have a good rest of your day.
You too. Bye-bye.
Okay. 9 o'clock calendar. Anybody else? We have this gentleman here. Oh,
No, number 9 on the calendar. I don't believe council is going to be present, but it's an agreed motion to continue.
okay. Give me one. Okay, this is City of Yelm versus Sky Tulalele, cause number 6A0006649, number 9 on the pretrial calendar. We have a motion to continue to April 23rd at 9 a.m. with a waiver with a commencement date of that date. City has no objection, so I will sign that order. Okay, and what's your name? Okay. All right, Mr. Holmes, why don't you come forward? I actually wasn't, that's a Pelon case, wasn't he? Not? Okay, so go ahead and have a seat. Mr. Huxford or?
Yes.
Okay, Mr. Huxford can't figure out Zoom. All right, is Mr. Huxford? Well, I think well, we can't really take your case till we get Mr. Huxford, so just have a seat. We'll call you right back. Okay, that's the Cole Holmes matter. Do we have a Michael Wilson? Michael J. Wilson, as opposed to Michael Ray Wilson, who we just dealt with. Attorney Pavel Kleiner. Do we know? Okay, well, we'll give it just a second. Those are the last two on the 9 o'clocks. Okay. On the which matter?
Sorry, it's the Michael J. Wilson.
Oh, okay. This is cause number 6A0006643, Michael J. Wilson. They provided an old school waiver or motion to continue with no. So they waived speedy, but they didn't give a date. So we'll just make the new commencement date today.
Yeah.
And Madam Clerk, on the Michael J. Wilson case, what would be the new date on that? Mr. Radfield, I don't like being that guy, but Mr. Kleiner should be able to figure out O courts. Okay. If you might just give him a note next time. Tell him I may not be taking this next time, just because, so. Okay. All righty. Now, speaking of inabilities to deal with technology, where's Mr. Huxford? Okay. Okay. All right, so if we want to, Mr. Havercoat, we have some 945s ready to do those. Mr. Havercoat, are you ready for some 945s? Are those yours? For the warrant quash calendar? We just have one, we're waiting for one lawyer on the 9 o'clock. I'll start, is there a Jacqueline Anderson present? We have a Daryl Hurley. All right, Shirley, let's come have a seat next to Mr. Haverco and we'll go from there. Let me know when you're ready.
Yeah.
Okay. Yep. Here. Who are you, sir? That's Daryl Hurley. Okay, give me. I think he must have left you last time, so we'll just do, let me get your, let me get a phone number again. I have an SOC in the file. You do? In the, yeah, in O courts. And that's what we're doing. So it's an SOC, yeah, it looks like an, from a DUI to a reckless, 60 months. That's, yeah, that's right. Only have inside. Yep. One second. Should have looked at my notes. This one. Right now. Yeah.
He is signed, Your Honor.
Okay. All right, this is City of Yelm versus Daryl Allen Hurley. All right, Mr. Hurley, cause number 580932941. Mr. Hurley is present out of custody with counsel, and I have before me charges DUI. I have before me a statement or a stipulated order of continuance. And Mr. Hurley, were you present earlier when I went through a number of these with some folks? And these are a contract, okay? You have enough time to go over this with Mr. Haverco? Okay. And did he talk about the benefits of this kind of agreement and also the things you're giving up, like your rights to a speedy trial, your right to hear and question witnesses? You give up rights to a jury trial. You understand those things? Okay. And you understand at the end of 60 months, this case is going to be, right now, for the next 60 months, this case is going to be kind of in a limbo. And in a limbo, subject to the conditions that are contained in this agreement. At the end of 60 months, if you've completed everything, paid the costs and done whatever you're supposed to do, you don't even have to come back in. The city will move to administratively amend it to a reckless driving. There will be a license suspension attached to that, which in today's day is 30 days. That could change between now and then, but for purposes of right now, you would get the benefit of the bargain and avoid some of the penalties of the DUI process. You understand that?
Yeah, one question is, sorry, the question would be as far as the license suspension, that 60 months or that current?
My assessment is that DOL won't impose the 30-day license suspension until the conviction is entered.
That's correct.
So, it's 5 years out.
Yep, that's correct. Yep. Okay. Now, if there was an administrative license suspension, you would normally, even 5 years from now, you would get credit if you did more than 30 days on whatever administrative license suspension. You wouldn't have to reserve that 30 days. They would give you credit. But again, that's up to DOL. Rules change. Things may be very different in 5 years. So, okay. Any questions, any other questions about this agreement? Okay. All right. I'm going to go ahead and sign this agreement, and we will go from there. You'll get a copy of this at the window. And I assume, is there a treatment component of this? Have you been evaluated yet? Okay, you're gonna have to do obviously any treatment that's required. Want that done in a timely fashion. And because if we don't get it, then we bring it back in. Okay, all right. Okay. Mr. Hurley, good luck to you. I've signed the order. Yep.
Was Jacqueline Anderson here? Or did the
She
court-
was not here.
She's not here.
At least she did. If she is, she didn't say anything.
Okay.
Oh, we have extras. Give us 2 seconds on this next case. Mr. Holmes, just come have a seat. All right, Mr. Oxford, are you present?
I am, Your Honor.
All right, good morning. You're here covering on the City of Yelm versus.
I couldn't figure out how to get in as somebody, as a participant rather than an attendee. I apologize for the wait.
No problem. No problem. So this is Cole Michael Holmes. Mr. Holmes is present, out of custody. My understanding is there's a agreement to continue this matter. Is that right?
That is my understanding as well. Ultimately, I believe that the parties have reached a resolution, but we just need to iron out a couple details. My understanding is just a 2-week set over is what Mr. Pilon has requested. I'm not sure where we're at in speedy trial. But if a waiver is necessary, my understanding is that that's been discussed with Mr. Holmes already yesterday.
We okay without a speedy? Okay. So, Mr. Oxford, we are booked pretty solid for March 26th and April 12th, April 9th. So
Okay.
we'd have to put, the earliest we could reset this would be April 23rd. And I think by doing that, we will need a waiver.
Okay, I think that what Mr. Pilon suggested is the date is fine. If the court doesn't have availability, it is what it is. What I can do is I can have Mr. Pilon's assistant get a waiver sent over in the next 15 minutes or so. And if the court would be willing to sign that ex parte, that would be great.
Yep, that's fine. Just have them loaded up into O courts with a commencement date of April 23rd, and we'll go from there, correct, for the city?
Okay. Did I hear the date correctly? April 23rd is the
April
next one.
23rd at what time? It'll be at 9 AM. So your next court date is going to be April 23rd at 9 AM. Be in touch with Mr. Pilon and Mr. Huxford's office. And then they're going to send in a waiver of speedy trial that we're going to sign. So your speedy trial will restart April 23rd. Okay. All right. Anything else on this matter?
Nothing else on for me, Your Honor. Thank you very much. I
All
appreciate
right.
it.
Thank you, Mr. Huxford. Mr. Holmes, good luck to you. You're ready, free to go April 23rd, 9 AM.
Thank
Okay.
you.
All right. Thank you, Mr. Huxford. All right, getting back to the 9:45, do we have a well, I'll let you call the calendar, Mr. Haverco, or would you like me to?
Oh, well, is there a Trevor Mocha here? Trevor Mocha?
No response?
The note says if FTA reset, no warrant. on the calendar.
Looks like we may have already done that.
Oh.
Okay.
We're gonna reset it.
Oh, okay.
Okay. Okay. Joshua Roos? No response. Isla Scheidek?
Yes.
Okay. What was the original warrant amount? Okay. Have we heard anything from any?
I've never been appointed to this person.
Oh, okay, because he needs to show up before we can
Yeah, he
appoint
needs
him. Okay. All right. Absent an objection from the city, we will note Mr. Joshua Roos's, and this is cause number XZ 0073779. We'll note Mr. Roos's non-appearance. This is for the second time, right? So, okay. So what we'll do is he's no longer eligible to quash the warrant by coming in. He'll be, if he comes in, he'll get taken in and then we'll deal with him.
Yeah, he can.
Yeah.
Or he can request to be back on the calendar.
Okay. Okay, Aaron Suppus? No response, and then that's it for the 9:45. So let's deal.
We call the matter of Isla Scheidek.
Isla Scheidek, I did. Okay, so Jacqueline Anderson, cause number 580900298, on for warrant quash. Miss Anderson, this was at 9:45. It's now 10:16. No response from Miss Anderson, and there's no one online, correct?
No.
Okay. Again, I assume we just issued the original. What was the?
So that warrant is still in place.
Okay. Leave it set. And then for Joshua Roos, we dealt with. Isla Scheidek, cause number 2A00939977. We've had 9 FTAs. And how did she get back on the calendar today?
She just requested an email out.
Okay, so let's not waste our time putting her on the calendar anymore. If no more call-ins, she can't. If she wants to come in, she's got to turn herself in. What's the warrant amount? And what is going to? Is there a bail amount that would make the police, if they catch her, would they hold her on 1,000? I just want to.
Out of agency, but I can let our police department know
Yeah.
to not to field.
Yep. If you can just make a note, yeah, no field booking, I'd like her taken in. Okay. And then, last but not least, cause number, City of Yelm versus Aaron Suppus, 580628215. That is a Mr. Haverco case on for pretrial. Any word from Mr. Suppus? Okay. What's the city's thoughts?
Strike the hearing and leave the warrant in place.
Okay, see what we got on Suppus. Lots of warrant. Let's go 2,500 cash or bond, please. All right, brings us to the 10 a.m.
Oh, okay.
Okay. Do we want to call those or you want to talk? Do we need to?
No, I don't think so. We're kind of ready to go.
Okay. Thank you, everyone, for being patient. We had a couple glitches this morning, so we're going to get caught up here. So we will call Mr. Killian Barrett or Mr. Barrett. There you go.
Yes.
All right. This is cause number 5A05576110, 5A0864568. Mr. Barrett is present via Zoom. I do note the calendar shows that it was authorized. So what are we doing? And Mr. Haverco is present in the courtroom. Mr. Barrett, what are we doing with Mr.?
We're going to, on the assault case, we're proposing the court accept a waiver of jury trial, and I have a proposed pretrial conference order in Oak Courts, and just pick a date for a bench trial and a trial confirmation date. And then I anticipate the city, given that on his suspended driving second degree case, given that he's now of suspended driving third degree status, the city might be amending to a civil infraction on that matter.
City's not doing that.
Oh, okay.
Okay. All right. So let's deal with the waiver of jury trial under cause number 5 for both matters, 5A0557610, 5A0864568. So Mr. Barrett, I have a proposed waiver of jury trial. Have you had a chance to go over that with Mr. Haverco?
Yes, Your Honor.
And do you authorize me and it's your intention to waive your right to a jury trial in this matter, not a bench trial, but a jury trial?
Yes, Your Honor.
You want me to sign this order?
Yes, Your Honor.
I will sign this order.
And then we'll just ask to join the suspended driving second degree case to set it together with the assault case.
Okay. All right. We're going to set these are going to be combined, both the cause numbers previously referenced. The next court date is going to be a readiness hearing that'll be set for May 7th at 10 a.m. with a bench trial to be held on May 21st of 2026.
Okay. Thank you, Your Honor.
General denial. And Mr. Barrett, obviously you'll have to be in person for those matters. Where are you located?
I'm in Henderson, Nevada.
Okay. So for the trial, you'll have to be here for sure. I'll authorize Zoom for the readiness, but
Okay.
for the trial, you're going to have to be here. We have a general denial. Okay. Let me look at one other thing. And Mr. Barrett, Mr. Haverco commented on this. It does look like your status is suspended third degree. Obviously, I don't need any comments as to why it's suspended third degree, but you are eligible for reinstatement. And obviously getting your license reinstated would probably be beneficial to you. So
Yes,
I'll
Your Honor.
refer to Mr. Haverco on that, and I will sign this order and leave it to the parties to keep talking it out. All right, Mr. Barrett, good luck to you, and we will make sure you stay in good contact with Mr. Haverco, okay?
Yes, Your Honor. Thank you.
All right, thank you. You can be excused.
Thank you, Your Honor.
Okay, David Campbell.
That's not what I mean. So we're on the cut. I don't know if there's a way to get the report maybe this morning and recall the case, but we're on the cusp of trying to enter a deferred prosecution, and I've been in communication with his treatment provider, so he's been evaluated, but I don't think that the evaluator understood that it needed to be a deferred
So I don't know whether we want to reset it or maybe have him reseat himself and maybe
Well-
try to call her and have her send it.
Well, if we reset it, it's gonna be put out to April 23rd. So about a month and a half.
I mean, you know, if we could maybe recall.
But
Okay.
if we do that, and he comes back in and we enter it on the 23rd, and you wanted to ask me to make it non-pro-tunc back to
Right.
today's date, I'd be okay with that, assuming he's in treatment and he's getting
Right.
things going. So we
Right.
could, I assume,
Oh, no, Jack.
yeah, so basically it'd be like entering it today, but we just get it entered when I'd rather you have time to go over with him. He has all the paperwork. I'd like to see him in treatment before we start this.
I was gonna mention to you, I am in treatment right now.
Okay, perfect.
I started,
Perfect, yeah, then that's perfect. And I mean, again, you guys could, but my recommendation is we take the time to get what we need
Okay.
from the folks, give you time to go over the deferred prosecution paperwork, if that's the way it's gonna go. And then just remind me on April 23rd that we
Okay.
talked about this and I'd have no objection, or I would be inclined to make it non-pro-tunc, which would make it date back to today's date.
Okay.
So your process starts today because you're in it. And if you've been in treatment for a couple months, there may even be or a month, there may be some discussions about even making it start sooner. Okay? Does that make sense, Mr. Haverko?
Sure.
Okay.
Yeah.
All right. So it sounds like we want to continue this matter to April 23rd. And is the city good with that process?
I've already got the information.
yesterday.
Double check my email and see.
She assured
Maybe-
me that it would be ready.
Let's see. Go ahead, let's see.
Okay. Let me find it.
Not yet. Does he need to sign a?
We just one, yeah. Next court date's gonna be April 23rd at 11 a.m. Sounds like you're doing well, though. Good, good.
Or you gotta have you sign.
Okay, I see the order, the resetting this matter to April 23rd, 2026, and I don't need to sign that, right? Okay, all right, Mr. Campbell, stay in touch with Mr. Haverko. Coordinate the treatment folks, and we'll see you back here on the 23rd. All right, thank you. And a copy of the order will be at the window to your right. Okay. And the next matter is William Dorsey. I have a note that indicates.
He's here, but he doesn't have a phone, so Mr. Dorsey just remains seated.
Well, but I think
Okay,
I've got notes that are indicating dismiss. Well, or is that just a new one? Okay, sorry.
oh, which one's getting dismissed?
The arraignment,
Oh, okay,
6A00204445 is going to be dismissed.
okay,
There is,
oh, got it, I see.
there were some discrepancies in it, so that was the request.
So I would just ask him to remain seated because
Okay.
I'll just try to talk to him on a break here.
So Mr. Dorsey, have a seat, just sit tight for a second. All right, next one would be Dylan Fritcher. This is cause number 6A00896668. Mr. Fritcher is present, out of custody, with counsel. What are we doing with Mr. Fritcher's case today? I have a guilty plea to an amended charge of neg one.
That's correct.
Okay.
Yep. And the reason it's not an SOC as it often is that the breath test was somewhat low.
Okay.
And no priors. And so the city was amenable to an amendment today.
Okay. All right, you are Dylan Fritcher. All right, good morning, Mr. Fritcher. So I've been handed forward a statement of defendant on plea of guilty to an amended charge of neg driving first degree. Do you have enough time to go over that with Mr. Haverco?
Yes, sir.
And do you feel like Mr. Haverco answered all your questions?
Yes, sir.
Okay. And did he read the agreement to you, or did you read it to yourself, or a little bit of both?
Both.
Okay. And I'm going to just touch on a couple high points. You understand you're giving up a number of constitutional rights by pleading guilty. And you understand there's a recommendation, maximum penalty, 90 days in jail, $1,000 fine, but there's a recommendation. I don't have to follow all of that. I could send, or I don't have to follow the recommendation. I could sentence you up to the maximum. Okay. Paragraph 11 states that on or about January 8th, 2026 in the city of Yelm, I drove a motor vehicle in a negligent manner, creating a risk to persons or property and while exhibiting the effects of alcohol. Is that your statement? So as to the charge, amended charge of DUI to a negligent driving to the charge, how do you plead to the charge of negligent driving? Guilty or not guilty? Okay, a finding plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea, and I'll hear from the city as it relates to sentencing.
Your Honor, it's an agreed recommendation.
Okay, Mr. Haverco? Agreed. All right, Mr. Fritcher, you don't have to say anything, but this is your opportunity to say something before sentencing. Is there anything you'd like to say? All right. So has Mr. Fritcher been evaluated yet?
I don't think so.
No.
Okay.
Gonna have to do the usual, DUI conditions, evaluation, comply with any treatment, if any. And,
Yep.
Victim impact analysis.
Okay.
It's just freedom of recovery.
And did we, what do we? So was the city aware Mr. Fritcher had the DUI from January 8th and now he's got he had a neg driving second, which may or may not be a violation of the original conditions, but no insurance. He was operating without insurance on January 15th.
City was not aware, but that doesn't change cities.
All right. So, Mr. Fritcher, the reason I asked, and this isn't, do you have insurance now?
No, I'm just trying to get that situated.
Okay, how old are you? Okay. All right. Well, so Mr. Fritcher, I hope you're taking this seriously. So I'm going to follow the recommendation. Your breath test was a little bit over 1.0, which is obviously still a violation. I'm going to impose 90 days in jail. We're going to suspend 90 days, the whole 90 days, going to impose $1,000, suspend $1,000 for a period of 12 months. Following conditions, you're to pay $250 probation monitoring fee. You're to get an alcohol drug evaluation and comply with any treatment. I'm going to have you do that I'd like to see that within 30 days. Okay. You're also complete any treatment. You're going to have you complete a victim's impact panel. So instead of 90, I'm going to give him 30 just because this case has been sitting out there since January. Complete the victim's impact panel within 90 days. Not drive without license and insurance. You're to comply with all rules as they relate to the Department of Licensing. Not to drive a motor vehicle without license and insurance, not to refuse to submit to a breath test if requested by any police or the court or any probation or any treatment provider. No criminal law violations, no alcohol related infractions. Okay. All right, Mr. Fritcher, I'm going to sign this order. You're going to get a copy at the window. You can figure out how to work with the city, how to pay the fines. Otherwise, hope not to see you back here again, all right? So you need to, all these conditions, you need to make sure get provided to the court, because if you do them and we don't get them, it's just like you didn't do them. All right, okay.
So do I just send it to him?
I'd send them to the court. I'd keep a copy for yourself and I'd send them to the court.
Okay.
All right?
Thank you.
Okay. Good luck to you.
Thank you.
You too. All right. Catherine Fry. Okay, come on forward, Ms. Fry. This is cause number 6A0021951. Ms. Fry is present, out of custody with Mr. Haverko.
If we could recall that, I need to speak with Ms. Fry.
Okay.
Yeah.
All right, Ms. Fry, just have a seat right up here in the front row. Any matters you have, anything ready?
Well, is Michael Heelan here?
No response.
Let's see.
Do we have McLeod? We had Zoom approved for McLeod. Nobody on Zoom yet.
Oh,
Oh,
McLeod?
okay. You need to talk to her?
No.
Okay. This is Violet Rose McLeod, cause number 6A0021949. Ms. McLeod is present, out of custody with Mr. Haverko.
She's signing an SOC. No courts. Matter to be continued for, 1 year on the condition of no new criminal law violations, $250 court fee, at the end of which time city would move to dismiss.
Okay. All right, Ms. McLeod, have you had enough time to go over this proposed stipulated order of continuance with Mr. Haverko? All right. Feel like he's answered all your questions? Okay, do you understand the contractual nature of this? You understand you're expected to do certain things in exchange the city's not going to do certain things? Okay. This matter, and then if you're successful at the end of this, the assault charge would be dismissed. If you're not successful, you'd be brought back in. Myself or whoever the judge is sitting here would read the police reports and determine your guilt or innocence based on those police reports. Okay. You understand that? Yes? Okay. All right. You're going to pay a $250 probation fee, no criminal law violations. You appear timely at all court hearings. Is there any no contact orders in place on this case?
I don't believe so.
Okay.
I didn't see one.
All right, Ms. McLeod, I'm going to sign this order. You'll get a copy of it and you'll get a copy at the window. And hopefully we don't see you back in here. All right, good luck to you.
I don't think Jason Tipton is here.
Not appear so. So do you want me to give you to take a break to talk to these folks?
Yeah.
Okay.
And you
All right, we're back on the record. This is City of Yelm versus Catherine Fry, cause number 6A0021951. Mr. Haverko.
Matter comes on for a pretrial, Your Honor. We placed a stipulated order of continuance in O courts. The matter to be continued 12 months on the condition of no new criminal law violations and a $100 court fee, and then dismiss upon completion.
All right, you are Catherine Fry? Okay, all right, Ms. Fry. Been handed forward a stipulated order of continuance. You feel like you've had enough time to go over this with Mr. Haverko? Did he answer all your questions? Okay. This is a 12-month SOC to dismissal. Conditions are pay $100, maintain law-abiding behavior, appear timely at all court hearings. And you understand if you comply with all of those conditions, at the end of the 12 months, this charge will be dismissed. If you don't comply, you understand you're giving up your rights to a jury trial, you're giving up your rights to really any sort of trial, giving up your rights to hear and question witnesses, all of those things. And then the judge, myself, or someone else will sit here and simply read the police reports and determine your guilt or innocence based on those police reports. You understand that?
Yes.
Okay. Still want me to sign this?
Yes.
Okay. All right. Anything else from the city?
Nothing from the city, Your Honor.
Okay, Mr. Haverko?
Nothing to add, Your Honor.
All right. Sign the order. Ms. Fry, you'll be able to get a copy of the order at the window. Okay, good luck to you.
Next matter would be Mr. Dorsey.
Good morning, Mr. Dorsey. Here on several cause numbers, 5A0864584, 6A0015691, 6A0020445, and 6A0097587. My understanding is the matter that's on for arraignment, which will be 6A0020445, is going to be dismissed.
That's correct. And I also just added that to the guilty plea form that's in O courts as a dismissal of that matter.
All right. And you are William D. Dorsey? All right. Good morning, Mr. Dorsey. This is, I've got before me a statement of defendant on plea of guilty. This document contains a plea to criminal trespass second degree, a plea to a amended charge from criminal trespass first degree to criminal trespass second degree. And then there'll be some dismissals if those pleas are accepted. Do you understand that? Okay. So this document, you understand by pleading guilty, if I accept your plea of guilty, you understand you're giving up your constitutional rights that are contained in paragraph 5 of the plea form?
You're given it. He understands he gives up his right to trial.
Okay.
If he pleads guilty.
And you understand the maximum penalty on each of these charges is 90 days in jail with a $1,000 fine. You understand there's a recommendation in here? I don't have to follow. I could sentence you up to the maximum. You understand that? Okay. Is that a yes? Sorry, I got it. Okay. All right. Paragraph 11 states, following occurred in the city of Yelm. On November 19th, 2025, I trespassed on Nisqually Plaza property. On January 2nd, 2026, I trespassed at 403 Yelm Avenue. And on January 23rd, 2026, I trespassed on the Yelm Middle School property. Are those your statements? So as to the charges of criminal trespass, second degree, alleged to have occurred on November 19th, 2025, January 2nd, 2026, and January 23rd, 2026. How do you plead, guilty or not guilty? Okay. Find your pleas are made knowingly and voluntarily. No one made any threats of any kind to cause you to enter the plea. Are we moving to sentencing today?
We are.
All right, I'll hear from the city first.
Your Honor, it's an agreed recommendation.
Okay, Mr. Haverko?
It's agreed.
All right. Mr. Dorsey, anything you'd like to say before sentencing? Yeah, I mean, you know, I don't know what your situation is, Mr. Dorsey, but you know, it's a residual of private property rights in our state. So if I have a piece of property sitting out there and you want to come and sit on it or camp on it, I can kick you off. If you don't leave, you're trespassing. Okay, does that make sense? So you just have to respect the boundaries of other people's property. Or what's gonna happen is the police are gonna get called and you're gonna get arrested. And, you know, you probably got picked up and taken in on this one. Yeah, and, you know, if these things keep piling up, it'll just get worse and worse and worse. So, okay? So you're gonna be, I'm gonna follow the recommendation. I'm going to, excuse me. I'm gonna follow the recommendation and impose 90 days in jail. I'm gonna, and suspend all 90 days, impose $1,000 fine, suspend all $1,000 on each case for a period of 12 months. Following conditions, and the city's moving to dismiss the other counts? Okay, I'll go grant that motion. Following conditions, Mr. Dorsey, law-abiding behavior, don't trespass on the properties, and the 403 address, the Yelm Middle School property, and the Yelm Plaza property, okay? Pretty simple. Can you do that? Okay, all right. I'll go ahead and sign this order. You'll be able to get a copy at the window in just a second. All right. And I've signed that order. Good luck to you, Mr. Dorsey.
Good luck. Next matter is gonna be Mr. Michael Zamudio. Got a couple matters, a mitigation and a pretrial matter on 6A00896660, suspended second degree and negligent driving first degree.
Okay,
And what we're
this is
gonna
on
do.
the 11 o'clock docket.
Yeah, yes, sir.
All right, is it Mikhail or Michael? Michael Zamudio. All right, Mr. Zamudio, we're here on customer 6A. There's a mitigation 6A00896659 and a pretrial for DWS second degree and neg driving first degree 6A00896660. And I'm sorry, Mr. Haverko, what are we doing today?
Oh, on the pretrial matter, I think he's actually eligible for a license. So city was gonna amend to no vol second degree. And then the city and I discussed count two, the neg one, and determined there was not actually really a factual basis for it. So city's gonna move to dismiss.
Okay. And is that correct from the city?
That is correct.
All right. So, you're Michael Zamudio? All right. And I did just look, you are eligible for reinstatement. You plan on getting your license back? Okay. So on the infraction disposition, we're gonna dismiss the neg driving first degree. We're gonna amend the DWS second degree to no vol with ID. What are we doing with the,
I think, I wasn't sure if the city wanted to pursue the rear mounted stoplight or dismiss. If,
City's fine dismissing.
please, what?
Dismissing the.
Okay. The rear center high mounted. Okay. So penalty will be $150. Mr. Zamudio, you're getting a fantastic deal on this. Okay. Don't waste it. Pay $150. You'll set up fine payments at the court. We'll give you a copy of this order and that'll resolve your case.
he's not sure. Was there a pretrial court order for him to have an ignition interlock device?
Madam Clerk, are you looking at?
Thanks for reminding.
Probably there was, because I'm sure there was, because there's a pending DUI out of Thurston County. Yeah, pretrial ignition interlock. So that condition would be released. You need to put that on the order. Okay, and that'll be sent into DOL, so that condition won't. Okay. Yeah, so that'll be taken care of. Okay, all right. Anything else, Mr. Haverko?
That's it.
All right, Mr. Zamudio, good luck to you.
Yeah.
Yeah.
Can-
All right, next matter.
Out of curiosity is, do we have Tina Dawson hopefully on Zoom? We do? Oh, okay. Fantastic. Go.
We moved entirely to the 11 o'clock calendar.
We have to revisit one matter, but let's do it after
Okay,
the 11th.
okay. So we got, looking for Tina Dawson. All right.
And I
I'm here.
Hello, good morning, Ms. Dawson.
Good morning.
So Ms. Dawson, first things first, do we have a good address for you?
I have been having problems getting mail at the address that I live at, but I do have a good mailing address for you guys.
Okay, how do you want to get that conveyed to you, to the clerk? Can you call, email? I'd prefer not to do it on the record, but I need you to call as soon as we're done here to the clerk and leave your good mailing address.
Okay.
Okay?
Yeah. Yeah. I can do that.
And don't forget, because we need it.
No problem.
And what are we doing with Miss Dawson's case today?
There should be, Your Honor, if it's not, I've got an extra copy, but there should have been a substance use evaluation placed in the file recommending deferred prosecution. If it's not in there, I have another copy.
I've got it. Okay.
And so we placed in Oak Court, it's a petition for deferred prosecution and an order, deferred prosecution order, which I filled out and signed. So we're asking the court to grant a petition for deferred prosecution in this case.
All right. All right, Ms. Dawson, I'm looking through the substance use disorder. Recommending deferred prosecution. Ms. Dawson, have you had a chance to, you've signed this substance abuse disorder evaluation, are you already in treatment?
I was unsure of whether I was supposed to start attending treatment after I saw you or before, so I started last week.
Okay, good. No, that's good.
Or this week, sorry.
All right. So you've had a chance to go through this petition. First thing I'm going to go over is the petition. Have you had a chance to review that thoroughly with Mr. Haverko?
It's been a while, but yes.
Okay. Do you feel like you understand the requirements of the deferred prosecution program?
I feel like I have a pretty good understanding of it. I know I can call Mr. Haverko if I have any questions.
Okay, Mr. Haverko, are we comfortable with pretty good understanding of it?
Yeah. Just to refresh, Ms. Dawson, so deferred prosecution, you're on oversight for 5 years, the first 2 years of which are basically active probation to supervise and monitor that you complete the 2-year treatment program. And then you're placed on unsupervised probation for another 3 years, at the end of which time, if you've complied, not had any new criminal law violations, not drinking alcohol, then the matter will be dismissed. And we have discussed that. Do you recall?
I do, now that you brought it up. I am confused about supervised probation.
Well, and how that works is you're obviously not here, you're in Montana. So as long as the court's getting progress reports that you're in compliance with treatment,
Okay.
have any hearings essentially, as long as you're in compliance.
Okay. All right. I understand. Okay.
All right.
Thank you, Mr. Haverko.
Thank you.
All right, so Ms. Dawson, I also have before me a deferred prosecution findings of facts and conclusions of law, which basically summarize everything you're agreeing to do. You are amendable to treatment. If you don't get treatment, you're likely to reoffend. You're agreeable to pay for the treatment. You're agreeable to complete the treatment. As part of this program, you're giving up your constitutional rights to a jury trial, speedy trial, to give testimony, call witnesses, present any evidence. You're also stipulating the admissibility of the police reports if this matter is moved towards revocation. Do you understand that?
Yes, I do.
Okay. And you've never been granted a deferred prosecution before. And you're aware of the consequences of unsuccessfully completing the deferred prosecution and those things. You understand? Is that true? You understand all those conditions?
I do understand those conditions.
Okay, I'm going to find that court has jurisdiction. You meet the requirements of the deferred prosecution program. I've reviewed the treatment provider's report from New Freedom Recovery Center, and I believe it meets the diagnostic and evaluation and commitment requirements of a deferred. And I'm also going to find that Ms. Dawson is eligible for deferred prosecution. So order will say you're to complete the 2-year treatment program administered by New Freedom Recovery. You're agreeing to pay all fees and costs. And you're going to provide proof of all of those, completion of all those terms to the Yelm Municipal Court. There'll be $990 in fees that will be assessed over the course of the 5-year program. You can make payments on that.
Okay, yeah. I'm unemployed right now. Do I qualify for any kind of like, I don't have the right word. Or do I just have to?
You have 5 years to make the payments. If that needs to be addressed at a later time, we can address that at a later time.
Okay.
The address that we have right now is the 2420 address. Does that sound familiar?
Yeah, that's the address that I should be able to get mail at.
Okay, and again, you're gonna call and just confirm that address when we're done.
Yeah, it could be something as simple as the wrong zip code. But yes.
Okay, and I'm sorry, just so you know, the total is not $991. That's a maximum penalty if you were convicted of the monetary penalty if you were convicted of the DUI. The costs for this deferred through Yelm are $500. So you can make payments towards that $500. Okay?
Okay, all right. I have 5 years to get that paid off, right?
That is correct.
Okay, thank you.
Anything else to cover, Mr. Aberco?
I don't think so.
All right.
I'm sorry, I don't mean to cut you off. There is one other thing to cover. I believe that part of this was also to quash a warrant because I mistakenly missed a court date.
That warrant would be quashed.
Okay, all right. Thank you.
Anything else from the city? All right. Miss Dawson, I've signed that order. You'll get copies of all of these things. You're going to call the city and confirm that we have a good address for you. And I wish you good luck.
All right. Thank you so much, sir. I'll call them right now.
All right. Take care.
You too. Bye-bye.
Oh, reseat yourself first. Yeah. Come on up. Yeah. Sorry about that.
And who is this?
This is Mr. Newman.
And what's going on?
Nothing. He's just having some blood sugar issues, and so he's just wanting to get hurt. So what we're doing here, so he's got a couple matters, a compliance matter and a protection order violation, and we've come up with a solution here. That being is he's going to enter on the pretrial matter ending in 1154. He's going to enter a guilty plea to the amended charge of disorderly conduct.
All right, this is City of Yelm versus Samuel Newman, cause number 4A0745401 and 5A0001154. We are on for pretrial on the 154 matter and a compliance on the diversion for 401. So why don't we deal with the diversion situation first? That's a protection order violation.
Go ahead and sign here. So what I think the parties were prepared to do here was upon the court's acceptance of the plea to the amended charge of disorderly conduct, then the parties would stipulate that as to the compliance matter, that's a violation.
So then the SOC be.
Yeah, correct.
Okay, all right.
Yeah.
All right, so then we'll deal with the 154 cause number first.
Right.
All right, and you are Samuel Newman? All right, Mr. Newman, I've had before me a statement of defendant on plea of guilty. What was your last level of education completed? Okay. All right, and I have the original charge of protection order violation, city moving to amend to disorderly conduct.
correct, Your Honor.
Okay. And Mr. Newman, did you have a chance to go over this form with Mr. Haverco? Okay, did he read it to you or do you read it yourself? Okay, did you feel like you had enough time for him to answer all your questions? I know, Mr. Newman, but listen, you're not gonna run this show here. I'm trying to get through it, so I want you to listen to Mr. Haverco. I'm gonna go through certain things with this. The quicker we can get through this, the easier it is for to do this, okay? I understand, so. Okay. Are we ready to go? Okay. Mr. Haverco, ready to go?
I think so.
Okay, all right. So the amended charge is disorderly conduct, and Mr. Newman, that's a misdemeanor. Means maximum penalty is 90 days in jail, $1,000 fine. There's a recommendation contained in this plea form that I don't necessarily have to follow. I get sent you up to the maximum. And you understand by pleading guilty, you're giving up a number of constitutional rights? Okay. And at paragraph 11, there's a statement that's written there. And you're making a plea pursuant to an Alfred plea, and it's in Ray Bar. So what I will do is I will just take a look at the police reports and then see what we've got, and then I can determine if the facts are sufficient to support the charge. And it's in Ray Bar, which loosely means it's giving me some flexibility, understanding that it may not fit entirely, but you're taking advantage of an offer. Okay, so give me just 1 second. All right, based on the nature of the plea, the Alfred plea in relation to In Re Bar, I will find, based on the agreement of the parties, a sufficient factual basis for the amended charge of disorderly conduct. So I will enter a plea of guilty or make a finding of plea of guilty to that charge. Are we moving to sentencing today, Mr. Radfield? Okay. Anything else from the city? All right, Mr. Haverco?
Nothing to add, Your Honor.
All right, Mr. Newman, this is your opportunity to say something, to explain.
My daughter she called me, she was having that need, so if I have to lose the feeding my child, I have to take that to parent. Just bring them something.
Okay,
To give away.
gotcha. Okay. Okay, and you know, the police reports say a little something different than that.
Well, they said I haven't done enough.
Yeah, yeah, I got it. No, I think that's probably pretty clear based on the resolution. Okay, all right, so what I'm going to do is on the judgment and sentence, Mr. Newman, I'm gonna follow the recommendation. I'm gonna impose 90 days in jail, suspend all 90 days, impose $1,000 fine, suspend all $1,000 for a period of 12 months, maintain law-abiding behavior. You're gonna pay a probation fee of $250. No criminal law violations, okay? I'll go ahead and sign this order. And then on the order on review of revocation under the previous no contact order violation, my understanding the parties agree that this new charge constitutes a violation and would result in revocation?
Yes.
And is it a revoke and close? Okay. So Mr. Newman, based on the new charge, the protection order violation that you were on for compliance review, simply the stipulated order of continuance is going to be revoked per agreement of the parties, and a finding of guilty will be entered, but then the case will be closed. Okay.
One more signature. Yeah, go. And you'll enter the plea of guilty will be, or the finding of guilty will be entered. Okay. 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 All right, Mr. Newman, I've signed that order, so you can pick up copies of them at the window, and I wish you good luck. Yep. Charlene Evans,
I didn't catch the last name, sorry.
Evans.
Charlene Evans? All right, this is cause number 580960637. What are we doing with Miss Evans today?
She is going to enter a plea, which is in Oak Courts.
All right, and you are Charlene Audette Evans, or Audette. And Miss Evans, charge is theft third degree. My understanding is your intention is to plead guilty to that charge? Okay. You have enough time to read through this document? Did you read through it with Mr. Haverko, or did he read it to you? Okay, do I feel you get enough time with him to go over everything and answer all your questions? Okay, and paragraph 5 contains a number of constitutional rights that by pleading guilty, you're giving up. Do you understand that? And do you understand that there's a recommendation in here that this is a misdemeanor, gross misdemeanor means maximum penalty is 364 days in jail with a $5,000 fine. You understand that there's a recommendation. I don't have to follow that. I could sentence you up to the maximum. Okay. Paragraph 11 states, on December 31st, 2025 in the city of Yelm, I stole merchandise from Walmart. Is that your statement? So as to the charge of theft alleged to have occurred on December 31st, 2025 in the city of Yelm, how do you plead guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one made any threats or promises of any kind to cause you to enter the plea. I'll turn to the city in terms of sentencing.
Your Honor, it's an agreed recommendation.
Okay, Mr. Haverko? Agreed, Your Honor. All right, and Ms. Evans, anything you'd like to say before sentencing? All right, so when I look at your record, Ms. Evans, how many prior thefts are you gonna have? Okay. So you have one from, I see one. That one was dismissed, 2, 3. So I've seen worse, I've seen better. So I'm gonna follow the recommendation. Gonna impose 364 days in jail. I'm gonna suspend all 364 for a period of 12 months. I'm gonna impose a $5,000 fine, suspend all $5,000. I'm gonna impose a $250 monitoring fee. You're to appear timely at all court hearings. You have no criminal law violations, and you're not to go on the property of Walmart. Do you understand that? Okay. Go ahead and sign that order. All right, you'll get a copy of this at the window out there to your right. And I hope I don't see you in here again. All right, good luck to you.
Sean Freese.
Sean Douglas Freese, cause number 6A002428 Mr. Freese is present out of custody. Looks like, Mr. Freese, you owe, I appointed court-appointed counsel, but with you to contribute to that process of $150. Has that been paid?
Not yet, I'm sorry, I didn't know I needed to pay that right away.
Is that correct, Madam Clerk? Yeah. When, okay,
I can start paying them relatively quickly.
okay,
In the next couple of weeks, I just got a job.
okay, all right. Okay, what do we do with Mr. Freese's case today?
He is going to plead as to the first charge, interlock. It's going to enter a straight plea. As to the suspended first, he's going to plead guilty to the amended charge of driving while license suspended in the second degree.
All right. All right. Okay, and you are Sean Douglas Freese?
Yes.
All right, Mr. Freese. Have a statement of intent on plea of guilty to operate a motor vehicle without ignition interlock, and then a proposed amended charge of a DWS first to a DWS second. Have you had a chance to go over this with Mr. Haverco?
Yes, sir.
Did he read it to you, or did you read it to yourself, or both?
He read it to me.
Okay. And did he answer all the questions that you have?
Yes.
You understand that these charges have a maximum penalty of 364 days in jail, $5,000 fine. You understand I don't have to follow any recommendation that's in here. I can sentence you up to the maximum.
Yes, sir.
Paragraph 11 states, on January 3rd, 2026, in the city of Yelm, I drove a motor vehicle without ignition interlock installed as required by Department of Licensing, and you also drove while your license was suspended, and you were not, and at the time when you were not eligible for reinstatement. Is that a true statement?
Yes, sir.
All right, so as to the charge of operating a motor vehicle without ignition interlock, how do you plead? Guilty or not guilty? And as to the charge of operating a motor vehicle while your license was suspended and you were not eligible for reinstatement, how do you plead? Guilty or not guilty? Find your pleas are made knowingly and voluntarily, and no one's made any threats or promises of any kind to cause you to enter the plea. And I'll hear from the city in terms of sentencing. Okay. Mr. Haverco? All right. Mr. Freeze, anything you'd like to say before sentencing?
No.
Okay. So on the no ignition interlock, I'm going to impose 364 days in jail. I'm going to suspend all 364 days for a period of 12 months. I'm going to impose a $5,000 fine. I'm going to suspend all $5,000. On the DWS second, I'll follow the recommendation. I'll impose 364 days in jail. I'll suspend all 364, impose $5,000 fine, suspend all $5,000 again for a period of 12 months. You're going to pay $250 probation monitoring fee. And then also we want to add the $150, the amount that he owes for the public defender. Is that a separate deal? Okay, okay. So total fines and total costs will be $400. I want payments to start on that. Okay. Okay. All right. Conditions are going to be appear timely at all court hearings, no criminal law violations. You're not to drive without a valid license and proof of liability insurance. And basically law-abiding behavior. Do you understand that? Okay. Do you have any idea what you need to do to get your license back?
It's quite a list.
Okay.
I do understand this. Take some more. She can take me from work and then I did paving, which I used to do before.
Right.
And even though I don't have a license. So, I'm gonna take the steps now to prepare to get my license. So relatively minor.
Yeah. Yep. All right. Well, I wish you, it looks like what you're looking at here is DUI by a phone. Yeah, I think you're habitual traffic offender, which is gonna, there's ways to deal with that, so, okay. All right, well, Mr. Freeze, good luck to you. Okay.
Oh, was their bond still posted?
It'll be exonerated, yeah, sorry. All right, good luck.
Cindy Whitbeck?
Yeah, I don't remember how. What's the highest grade you got this? Right? Did you ever get a GD or anything? Okay. All right, this is City of Yelm versus Cindy Whitbeck, customer 580859875.
Sign here. We placed a statement of defendant on plea of guilty into O courts. He's going to enter an Alfred plea as to count 2 trespass first, and Alfred plea to the amended charge of criminal trespass second degree. an Alford plea to the theft charge, and then upon the court's acceptance of those pleas, city would move to dismiss the paraphernalia charge.
All right, and you are Cindy Whitbeck? Is that yes? Yes. All right, Ms. Whitbeck, I've had before a statement of defendant on plea of guilty to a theft third degree, as well as an amended charge of criminal trespass second degree. Upon acceptance, what sounds like it's the understanding of the parties, the city would move to dismiss the cause number for the use of drug paraphernalia. Is that your understanding? Yeah. Okay. You had a chance to read through this document, or did Mr. Haverko read it to you? You have or have not? Did he read it to you?
The statement of defendant on plea of guilty.
Oh, yeah,
Yeah.
Okay, did Mr. Haverko read this to you? Okay, have you had enough time to spend with Mr. Haverko to make sure you understand it, that he's answered all your questions? Okay, do you feel like he's answered all of your questions? Okay. All right, so paragraph 11 states, well, these are Alfred pleas. Okay, so what I do, Ms. Whitbeck, is I'm going to review the police reports, and I'll determine whether or not the facts are sufficient in these documents to support the finding of, in this case, an amended charge of criminal trespass, second degree, as well as a theft third degree. All right, based on the review of the police reports, I am going to find there's more than sufficient evidence to support the factual basis for these two charges, and I will enter pleas of finding of guilty as to both the theft third degree and the criminal trespass second degree. Is the city moving to dismiss the paraphernalia charge?
Yes, sir.
All right. Okay. Sign the finding of guilty. All right. What are we going to move to sentencing today? We are. All right, I'll hear from the city first.
Your Honor, it's an agreed.
Mr. Haverko? It's agreed, Your Honor. All right. Ms. Whitbeck, anything you'd like me to consider before sentencing? Okay. So, Ms. Whitbeck, I'm looking at your criminal history. You haven't had much you haven't had much for a long time. I guess one thing that always concerns me with these Alfred pleas is it forces me to read the police reports. I didn't hear any evidence, obviously, and the police reports are pretty clear that you've been trespassed from other Walmarts. Did we do any searches, I'm curious, I don't have access to it, but I'd be curious what your criminal history, if I looked at your criminal history in Oregon, what would I find? Couple thefts? Okay. Well, it's not getting cleared up, sounds like. And also I read through this, and if I go into a Walmart and I put a bunch of candy bars in my pocket and I forget to pay for them, that's theft. I mean, you understand that, right? So if you do it again, you're going to end up in the exact same position. I understand people make mistakes, but when you're already trespassed from Walmarts and you have a history, even though it's old history, you're not going to be given a lot of grace in terms of loss prevention and things like that. So do you understand that? Okay. So I just want to make it really clear, I assume you live in Yelm. Okay, well, you live in Portland. If you come to Yelm again and you get caught stealing anything, you're probably gonna be staying here against your will for a period of time. And I just wanna make sure you understand that. Okay. So I will follow the recommendation, dismiss the paraphernalia charge. Gonna find you guilty as I already found you guilty on the criminal trespass. I'm gonna impose 90 days in jail. I'm gonna suspend 90 days, $1,000 fine, suspend all $1,000. Jurisdiction will be for 12 months. Gonna impose 364, suspend all 364, and impose $5,000 fine, suspend all $5,000 on the theft third degree for a period of 12 months. Conditions are gonna be, you're gonna pay a probation monitoring fee up here of $250. You're not to have any criminal law violations, you're to appear timely at all court hearings, and you're not to go on the property of Walmart. You understand that? Okay. Now, the one thing with the $250 up here, people that sometimes live out of state think they can come up here and then, oh, I'll just forget about the $250. This case will not be closed. And if it gets to the point where you're not making any payments, you'll get a warrant at some point for non-compliance. So if you want to get this case resolved, if you want to get this sort of off your back, so to speak, you got to comply with all of these conditions. Okay? All right. All right, I'll sign this order. And Ms. Whitbeck, you're going to be given a copy at the window. You can call this court anytime and find out how to make payments. All right, good luck to you. All right, what's your name?
Please say your last name. This is he's number 5. It's Kalea Weha / Hanson.
Okay. And is your first name, is Ali? Alihi? Ali Kalawahe Hanson? Kalevahea, okay. All right. I don't want to disrespect you by mispronouncing your name. So what's your first name? Aliyah? Alihi? All right. All right. Alihi, I'm just going to refer to you as by your first name. Not out of disrespect, just because I don't want to butcher your last name a million times. So Alihi, this is cause number 6A00100609. You're here for pretrial, present out of custody with Mr. Haverco. Mr. Haverco.
We placed into Oak Courts a stipulated order of continuance there. One of the conditions stated therein and that the matters to be managed. And I can't afford to the evaluation.
Okay. And how old are you, Alihi? Okay. And so I've been handed forward a couple things. First thing is the alcohol evaluation treatment that you got through Providence. Looks like they're recommending how much treatment? Anything, let's see. The level 2 youth, what's your understanding of how much treatment they're requiring? You know? So it's a level 2.1, which means random UAs is medically necessary. 10 2 sober support groups and abstain from all mood, mind altering drugs. Looks like it's not a ton of treatment. Okay, so it looks like there's some treatment required, but not a ton of treatment, right? Okay, so Alihi, I've been handed also forward a stipulated order of continuance. Did you have a chance to read through this with Mr. Haverco? Okay, and do you feel like you understand what it is? And I'm gonna go over some points with that. So this is a contract. You're agreeing to do certain things in exchange for the city agreeing not to do certain things. And if you successfully comply with all the terms of this agreement, at the end of this, I think it was for 24 months, this matter will come back up and the DUI will be amended to a neg driving, okay? If you violate the conditions of this at any time during the next 2 years, compliance issues would be not doing your treatment, getting another criminal offense, not paying the costs, whatever it might be. If you're brought back in, the city can make a motion to revoke this because it's a contract between you and the city. And what would happen is in this contract, you're giving up your right to have a trial. You're giving up your right to question witnesses and call witnesses. And you're also stipulating that the police reports are sufficient to find you guilty of the charge of DUI if we get to that point. Do you understand that? Okay. And so what would happen is if you violate this, you're going to be brought back in and you're going to be convicted of a DUI. Okay. You understand that? All right. Now, if you don't, you get the benefit of this bargain. And there's a lot of benefits to this that I'm not going to get into, but again, this is a good deal. The problem is you're 17 years old. And from the evaluation, it talks about, you might have some cannabis issues, you might have some alcohol issues, or at least crave them, as they say. I mean, you realize in a nutshell, you drink between now and the time you're 21, you're breaking the law, right? If you smoke pot between now and when you're 21, you're breaking the law, right? Yeah, I mean, but so I'll tell you something. When I was your age, some buddies and I went fishing for just a day, minding our own business. I've probably told this story before. And we weren't doing anything wrong. We were just out on a boat fishing. And we came back with about $1,000 worth of tickets because we had beer, we didn't have licenses, we were using illegal, we were pretty much doing everything illegal. And I remember coming back and my dad swung by and I said, I was complaining about it. And my dad looks at me and he said, you know what your problem is? He goes, your problem is you're breaking the law all the time. And it made me think because he was absolutely right. Everything my buddies and I did that involved alcohol when I was under the age of 21 was breaking the law. It wasn't a question of if we were going to get caught. It was just when and how often. So the biggest thing I want to make sure you're 17 years old. You are now in a different category than your buddies. So if you and I were buddies and this weekend we want to go drink beer and I don't have this, I'm not under an agreement with this court, I'm in a very different position than you are because if I get caught, it's not going to be such a big deal. If you get caught, it's a big deal. Make sense? And it's just something you're going to have to think about because you've got to be smarter than the guys that you're around because you've got more to lose. Okay? And I just worry because you're young and you're out doing what you're doing, but you have to think more. And if you get behind the wheel of a vehicle again doing this, it's going to be a disaster. And you're either going to do a fair amount of jail time at 17 or 18 years old, or you're going to be doing an enormous amount of treatment. And then you're going to have to carry that the rest of your life. So don't saddle yourself at 17 years old with a mess if you can avoid it. Okay? Okay. All right. So I'm going to follow the record. I'm going to sign the SOC. You're not to drive without valid license and proof of liability insurance. You're not to be in, obviously, possession of a vehicle with actually above 0.02 or higher. So because you're under the age of 21. Not to refuse to submit to a breath test or blood test upon request of law enforcement. You're not to refuse an alcohol drug test upon request of court, probation, or training treatment provider. You got the alcohol evaluation good. You're going to complete any treatment that's required within 90 days. We're also going to have you do a victims impact panel, which is a 2-hour class. Look those up. Want that done within 90 days. Again, stay out of trouble. Let me look at one other thing here. My nickel bet is, you don't even have a driver's license, do you? I don't even, oh, I'm looking at a different guy. Hold on a second. Yeah, you're suspended, revoked, second degree. So that'll be at least probably till you're 18. Yeah. So I think, is your father? Yeah, your dad's here. Your dad's probably worried about you too. Just again, Alihi, think. Okay? Think about it. So, all right, I'll sign the order, and I hope that you get through this with no problems. All right? And tell your buddies, same thing, that you're the test case. Let them know kind of how much of an issue this is and what you're dealing with. All right? Okay. All right, Alihi, I'm going to sign this order. You can get a copy at the window. And I wish you the best of luck. Okay? Good luck to you. What's that? 250. Yep. Good. And you'll go to the window to the right today. Yep. Good luck to you.
And the last matter that corresponds with someone who's here is on the 10 o'clock calendar. Mr. Tipton was late. I don't remember what time he got here, but he wasn't here for the calendar at 10 o'clock.
All right. Good morning or good afternoon, Mr. Tipton. Why, how late were you? That's it? I think it might be more like 45 minutes late. Yeah, okay. But you were late, so obviously we prefer you to be at court on time. What are we doing with Mr. Tipton's matters?
Well, one of the things that it's getting a little frustrating for me. I've made notes on his 4A case, the one that starts with 4A.
Yep.
Okay.
There's actually 3 of them that start with 4A.
Oh, okay. So I guess I made the notes on the one ending in 275. So just for the court's information, on 221-25, 224-25, 417-25, 613-25, 724-25, 1726, 112-26. I've called him. He's never called me back. And then he arrives late, and then we wind up resetting it. So we're sort of in this endless spin cycle. So I don't know how to.
You guys, my mom.
What's that?
I give you guys my mom.
I have called a number that you've given me numerous times. So I'm not prepared today, so I don't know what we're doing. And so I guess I would have to ask to reset. But again, if he keeps showing up late, then, and he doesn't answer my calls, then we're just gonna keep doing this, I guess, in perpetuity.
That's the case, Your Honor. City's gonna ask.
Okay. So these cases are from July. Well,
We have some cases.
and their compliance issues, we have new law violations. Yeah.
Pre-trial from, ones from December 2024.
Okay. So Mr. Tipton, what I'm going to do is this. I mean, you were late today. These cases, you're on compliance for diversions from 2024. We have new law violations from December of 2024. We have new law violation from July of 2025. We're late today. Mr. Haverco, it sounds like, has made multiple attempts to get a hold of you. What I'm going to do is on the on cause number, based on violations of the conditions of release under 4A0901275, I'm going to impose a bail amount of $1,000 cash or bond. Okay? You're going to be able to post that. Okay. What I'm going to do is we're going to post a bond of on the 275, $1,000 cash or bond. I'm going to set this for 2 weeks. I know we're getting bold.
That's okay. It was just the 9 o'clock.
Okay. Okay.
Yeah, we're good for custody.
So I'm going to impose $1,000 cash or bond, which you're going to be taken into custody until you post. Okay. If you post, your next court date's gonna be in 2 weeks, which is gonna be March 26th. I want you here on time. I want you to be in contact with Mr. Haverco. He's in the book, you can find him. If you haven't heard from him, you say, Mr. Haverco, why haven't you called me? Right? Okay, you haven't done that, but we're gonna move this case forward one way or the other. Okay? So it's either gonna be with you in custody the next 2 weeks, or you can post, which then puts some, gives you some skin in the game because you are costing the court a ton of time and a ton of time and a ton of time. So. I'm sorry? Okay, well, what we're gonna do is we're gonna take you in on the $1,000 cash or bond today. And if you post, we'll see it. Either way, we're gonna see it back here on March 26th. Okay? And that'll be all for today. Thank you, officer. So I've got a,
We have some no-shows. Not a lot.
okay, we just do it, I've got a meeting at noon. Go ahead.
Okay.
Okay.
Did we, so Mr. Michael Heelan didn't appear and I don't have any information.
Okay, cause number 580932945. Michael Heelan, no response, malicious mischief, third degree. What's the city's thoughts?
City likes to take one issue.
500 cash or bond, please. Okay, Karina Crookston. Cause number 6A0097587583. Theft third degree. No response.
She had no phone, so I had no way of, I have no information.
Okay. 500 cash or bond. Jacob S. Moore, cause number 580051876. DWS third, no ignition interlock.
He last FTA'd on 129 and had no contact with him.
$1,000 cash or bond. And then Tipton we dealt with. What's that? Oh, yeah. Sorry. Okay, that's it. Case ready to go? Okay. Okay. Is this Clayton Grubb?
Yes,
All right. And we're on the record? Okay, this is City of Yelm versus Clayton Grubb, 6A0041282. Ms. Farina?
Yes, thank you, Your Honor. John Green, I'm the judge who is seated to my right. We are ready to proceed to our findings today.
Okay. And I will turn it over to you.
Thank you, Your Honor. We acknowledge receipt of the information, wait formal reading, and will enter pleas of not guilty.
Okay. All right. So Mr. Grubb, we're going to find probable cause for purposes hearing only. We're going to enter a plea of not guilty based on the statement of your attorneys. Now what I'm going to do is I'm going to turn to the city in terms of conditions of release. And so I'll hear from Mr. Ratfield.
Your Honor, city's just asking for,
Okay. Any objection to those conditions?
Yeah, yeah.
Okay. All right. So Mr. Grubb, you're going to be released on your own recognizance. Under the following conditions. Those conditions are going to be you're to appear timely at all court hearings. You're going to not have any criminal law violations, keep your name and address and everything up to speed with court and DOL, and you're not to have any contact with is it Brittany Grubb? Okay, no contact with Brittany Grubb. Is that going to be an issue?
No, Your Honor.
Okay. So no contact with Brittany Grubb while this matter is pending. We'll give you an out of custody court date and April 23rd or May 7th. Okay.
Thank you.
Okay, next court date is going to be April 23rd at 9 a.m. Mr. Grubb, stay in contact with Ms. Farina and we'll move forward from there. All right, is that all you have?
Yes.
All right, thank you. And oh, you'll be able to get a copy of this at the window to the right. Okay, we have one other is that for the David Gagnon? No? Is there David Gagnon present? Well, why don't we call up Miss Bowden? I don't. All right, well, we can come back to it. Okay.
Jenner, and I am here on Gagnon.
Okay, you're here on the David Wayne Gagnon matter?
Yes.
All right, Mr. Gagnon's present. Come have a seat. This is cause number 6A0006692. The matter's on for arraignment. Mr. Gagnon's present in court. Ms. Bowden's present via Zoom. On for arraignment, Ms. Bowden.
Yes, Your Honor. We wish to enter a plea of not guilty, waive any formal reading, and stipulate to probable cause for the purposes of today's hearing.
Okay, so Mr. Gagnon, based on the statements of your counsel, we're going to find probable cause for purposes of this hearing only. We're going to enter a plea of not guilty on your behalf. And what I'm going to do is I'm going to turn my attention to the city to discuss conditions of release.
standard conditions, Your Honor.
Okay. Recommendations for standard conditions, Ms. Bowden, any objection to that?
No objection.
All right, so Mr. Gagnon, you're going to be released under own recognizance. Following conditions are going to be no law violations, no criminal law violations. Keep your address and everything up to speed with the court and DOL. Appear timely at all court hearings and stay in contact with Ms. Bowden. Understand those conditions? Okay, we're going to give you another court date here in just a second. Ms. Bowden, we're looking at April 23rd or May May 7th,
Let's take the April 23rd.
23rd at 9 a.m.
Yes.
Treatment?
Mr. Gagnon's indicating he's going to be in treatment during that period.
He may be an inpatient, Your Honor. So if he is on that date, I'll file a 3.4.
So we're going to set it for that date. If you're unavailable, we'll be able to continue it at that time. Okay. Okay, April 23rd, 9 a.m.
Thank you, Your Honor.
All right, thank you.
Thank you, counsel.
All right, Mr. Gagnon, we're going to be able to get a copy of that order at the window to the right, okay?
Thank you.
All right, stay in touch with Ms. Bowden.
Bye-bye.
All right, thank you. Okay, do we have any other private counsel? Why don't you come on forward? Who do you have?
Ms. Brandy Sandy, Your Honor.
This is Brandy Lynn Saby. All right, good afternoon, Ms. Saby. This is cause number 6A0061891. You're here with Mr. Holcomb on for Raymond. Mr. Holcomb, I'll turn it over to you.
Thank you, Your Honor. My name is Andrew Holcomb. I'm an attorney of record in this case. I've advised my clients of her rights and arrangements. I believe she does understand them. I've also advised her of the maximum and minimum penalties associated with the offense. We're ready to stipulate the probable cause and enter a not guilty plea today.
All right, thank you very much. So Ms. Saby, based on the statements of your counsel, we're going to find probable cause for purposes hearing only. We're going to enter a plea of not guilty on your behalf. I'm now going to turn my attention to the city prosecutor for purposes of release conditions.
It's just standard conditions, Your Honor.
Okay, any objection to those conditions, Mr. Holcomb? This is
No
the first, it
objection.
looks like a first offense DUI.
That is correct,
Okay.
Your Honor. It's a first ever criminal charge. In fact, no objection to standard DUI conditions. I would just note for the court, my client does reside in Ferndale, so I just wanted to ask the court if she would have permission to appear over Zoom for future hearings.
She would, the only, no objection for future hearings, unless we get to a point of disposition. I think if disposition, I might wonder, but we can also talk about that. Okay, okay. All right, so Ms. Saby, you're gonna be released on your own recognizance, following conditions, no criminal law violations. You are to appear timely at all court hearings. Keep your address and phone number, or address and name and everything up to speed with DOL. You're not to drive without valid license and proof of liability insurance. You're not to drive or be in physical control of the motor vehicle after consuming any alcohol. You're not to have any alcohol-related infractions, not to refuse to submit to a breath test of blood upon the request of law enforcement, the court, or probation. Again, you're not to possess or consume any alcohol. You're also not to go to any bars or taverns, okay? We'll give you another court date, which is going to be April 23rd or May 7th.
April 23rd, Your Honor.
Okay, it'll be April 23rd at 9 a.m. Okay, was there bond posted on this? I'll go ahead and make a note, based on her appearance and our retaining of counsel, we can go ahead and release the bond. Okay, you're welcome. And that'll all be in this order. You'll get a copy of it at the window. And there we go. April 23rd, 9 a.m. And Zoom is appropriate. Again, if we do get to a point of disposition, I think we just need to confirm that, but we'll see where we're at. Okay, I've signed the order. Mr. Holcomb, any other matters?
No other matters.
All right, good seeing you again. And copy of the order will be at the window. All right, good luck. Okay, now I know we have one interpreter matter. Mr. Mold, why don't you come forward? Oh, okay. Why don't we? Which one is that? Okay. And I know, Mr. Mold, you are on record as sworn in for this court, so I won't go through that again. This is City of Yelm versus Maria Valdez Robledo. Cause number 6A0002325 on for arraignment.
$2,000 a month net, has a son.
Okay, dependent son?
Yeah.
Okay, all right. I will find Miss Valdez Rebelero eligible for court-appointed counsel at no expense to her. So I'll turn it over to you, Mr. Haverko.
Stipulate to probable cause, ask the court to enter a not guilty plea.
Okay. Finding a plea of not, stipulating the probable cause for purposes hearing only, entering a plea of not guilty as to the charge of theft third degree, conditions of release from the city.
Standard conditions, Your Honor.
Any objection, Mr. Haverko? No? Okay. Ms. Valdez Robelero, you're going to be released on your own recognizance on the following conditions. Those conditions are going to be, you're not to commit any criminal law or criminal traffic violations. You're to appear timely at all court hearings. You keep your name and address up to speed with Department of Licensing. You're not to go onto the property of Walmart. And you're going to be appointed Mr. Haverko as your attorney, and you are to be in contact with Mr. Haverko. So we want to make sure he has a good phone number for you and you have a good phone number for him. Next court date is going to be May 7th at 11 a.m. Oh, hold on a second, it's changed. Okay, next court date. And the next court date is going to be April 23rd at 10 a.m. And it'll be in the order. Good to go?
Good to go.
Okay, we'll see you back here on April 23rd. And I think that's the only interpreter matter. Thank you, Mr. Mold. Thank you. Okay. So what we're going to do now is we're just going to kind of go through the docket from the top. So folks, when you're done in here, our regular clerk is not in today, so you're actually going to go out of these doors to the right, and you're going to copy of whatever orders we get signed off on today. And so we'll get through these as quick as we can. The first matter I'm going to call is City of Yelm versus Kolisi Aune. Am I pronouncing that correctly? Aune? Aune? Okay. All right, Mr. Onai, this is cause number 680010674. Mr. Onai is present, out of custody, charges DUI. Mr. Haverko, have you inquired?
Takes home about $3,500.
Any dependents?
How old is the child? 6 and 3, 2 kids at home.
Okay. All right, I'll find Mr. Onay is eligible for court-appointed counsel at no expense to him, and I'll turn over to you, Mr. Haverko.
Stipulate probable cause, ask the court to enter not guilty plea.
Okay. Mr. Onay, I'm going to enter a plea of find probable cause purposes hearing only, enter a plea of not guilty on your behalf. Hear from looks like this is a first offense DUI.
I don't see anything indicating otherwise.
Okay. Standard conditions?
Standard.
All right. Mr. Onai, we're going to release you on your own recognizance under the following conditions. You're to appear timely at all court hearings. You're not to have any criminal law violations while this is pending. You're to keep your name and address up to correct with DOL and the courts. You're not to drive without valid license and proof of liability insurance. You're not to be in physical control of motor vehicle with alcohol concentration of 0.08 or higher. No alcohol-related infractions. You're not to refuse to submit to a breath test of your breath or blood if directed to do so by law enforcement, this court, or treatment provider. And actually, you're not to possess or consume any alcohol or non-prescribed drugs. And you're not to go to any bars or taverns while this is pending. Do you understand those conditions? Okay. We're going to appoint Mr. Haverco. Your next court date is going to be May 7th at 11 a.m. You're going to be given information on how to contact Mr. Haverco, make sure he has good information for you, and we'll go from there.
We're fine. Okay. All right, you're free to go.
All right. Okay, City versus Ryan Averill. Is there a Ryan Averill present? No response. Is there a True Barrientes? No response. Jeffrey Brown? Brown, let's come forward. So, Mr. Brown, this is cause number 6A00100671. Charges driving with suspended license. I'm going to turn to the city. This court has the city has a general practice as it relates to driving with suspended licenses. In this case, a driving with suspended license third, the city makes a motion to amend the charge to an infraction of no valid operating license with ID. And at that point, impose a monetary penalty of $150. If you want to accept that, we can do an order and you can pick it up here, then you get, okay. Now, obviously, Mr. Brown, I'm still going to recommend that you get your license back. Good. Okay. And I'm showing you've got, just so you know, you have a warrant out of Sumner Municipal. Does that sound about right? Okay, so you are taking care. Good, good for you. Okay. So what we'll do is I'll do an order that'll amend this to an infraction, impose a $150 fine. And we'll give you a copy of that and you can be on your way. Okay. Give me just 1 second. Okay. I've signed that order. You can come forward and grab a copy, or actually you'll grab a copy here, right? Or at the window? At the window. Okay. All right. Yep. Thank you. Good luck. Next matter is City versus Brian Browning. Good afternoon, Mr. Browning. This is cause number 6A00100672. You, my friend, are in the same position as Mr. Brown. You are charged with driving license suspended in the 3rd degree. And what the city does in this situation is the city moves to amend this to an infraction of no valid operating license with ID and impose a $150 fine. Is that something you want to take advantage of? Okay. So I'm going to do that. And do you know what you need to do to get your license back? Okay. Okay. Open, you're going to do that. And so we'll fill out this order and you'll come forward. You'll grab a copy at the window. Give me just 1 second. Okay. And amending it to NVOL with ID, $150 fine. I've signed that order. And you can go to the window and get it taken care of. All right. Good luck to you. Next matter is City versus Laurel Dawn Cates. Good afternoon, Ms. Cates. This is cause number 6A00242996. Charges use of drug paraphernalia. Ms. Cates is present with counsel or next to Mr. Haverco. Mr. Haverco, I'll have you inquire.
receives $967 per month on disability.
Okay. All right, Ms. Cates, I am going to find you eligible for court-appointed counsel at no expense to you. I'll turn over to Mr. Haverko.
Relate to probable cause as court gender not guilty plea.
Okay. All right, Ms. Cates, based on statements of counsel, we're going to find probable cause purpose of this hearing only and enter a plea of not guilty to the charge of use of drug paraphernalia. Conditions of release from the city.
Standard, Your Honor.
Okay. Standard conditions, Ms. Cates, are going to be, you're not to commit a criminal law or criminal traffic violations. Keep your address and name up to speed with the Department of Licensing in this court. You to appear timely at all court hearings. You're going to be given information on how to contact Mr. Haverko. I want to make sure, it sounds like you guys already exchanged information. Stay in touch with him. If you haven't heard from him, call him. And we're going to see you back here on May 7th at 11 a.m. Okay? And again, you'll go out to the window to the right to pick up a copy of this order. All right, next case, City of Yelm versus Jonathan Chapman. All right. Mr. Chapman, this is cause number 580072281. You are charged with use of drug paraphernalia and loitering, allegation of drug-related activity. Mr. Chapman is present. Out of custody, I'll ask Mr. Haverko to inquire.
He's not working at the moment, but he's shortly going to be starting a job making, Saturday, he's going to start a job making minimum wage.
Okay. All right, I will find him eligible for court-appointed counsel at no expense to him, and I'll turn over to you, Mr.
Relate to probable cause as court gender not guilty plea.
All right, based on statements of counsel, I'll find probable cause purposes hearing only, enter a plea of not guilty. Conditions of release from the city. All right. So Mr. Chapman, I'm looking at your criminal history. You have a warrant out of Thurston, it's Olympia Municipal Court, which is now Thurston County District Court. Well, I don't know what it is, but it's a warrant. So you plan on getting that taken care of? Okay. Okay. So what I'm going to do is your conditions of release are going to be no criminal law violations, stay in touch with Mr. Haverko, appear timely at all court hearings. I am going to okay.
And they took me to the museum at
Yep.
charge back. Should have been taken care of. That got taken care of already. I just got out.
Okay. Okay. Well, that can be something that Mr. Haverko can deal with the prosecutor, but right now it's not dealt with. So we'll deal with it. What am I looking at here? I'm going to impose also the condition of your release is going to be you're going to stay off the property of the American Family Insurance Gravity Learning Center with an address of 609 Yelm Avenue West. So you're not to go back to that property. Is that going to be an issue?
No, that won't be an issue.
Okay. All right. Next court date is going to be May 7th, 10 a.m.
It'll be in your paperwork.
And Mr. Chapman, since you just got out, I'm assuming, hopefully everything's good and you'll get all this stuff taken care of, and then you can come back here on 7th, stay in touch with that guy, and we'll get this case resolved. All right. All right. Good. Good luck to you. And there's gonna be a copy of this order at the window.
Yeah.
All right, City of Yelm versus Jack Chenier. Am I pronouncing your last name correctly? Chenier? Chenier, okay, all right. Mr. Chenier, this is cause number 6A0006663. Mr. Chenier is present with Mr. Haverco. I'll turn it over to you for inquiry, Mr. Haverco.
It's SSI 994 a month.
All right, fine. Mr. Chenier is eligible for court-appointed counsel at no expense to himself, and I'll turn it over to you for arraignment.
Stipulate to probable cause, that's the court to enter not guilty plea.
All right, find probable cause for purposes of hearing only, and we will enter a plea of not guilty. Turn over to the city for conditions of release. Okay. Looks like this is the okay. Conditions are the proposal standard conditions. Mr. Haverco, I assume no objection.
Objection.
All right, so Mr. Chenier, I'm going to release you on your own recognizance, following conditions. You are appear timely at all court hearings, don't have any criminal law violations, keep your address and name and everything up to speed with the court. You're also to have no contact with a Rachel Halderman. Is that going to be an issue? Okay. Going to appoint Mr. Haverco. His information is going to be on this form. Make sure he has good information for you. Next court date is going to be May 7th at 11 a.m. and be in touch with Mr. Haverco well before then, okay? All right. I'll sign this order and there'll be a copy for you at the window. Okay. Good luck to you. Grab an order out there. Next case, City versus Stephen Conway.
I'd be contacting you.
All right. Good afternoon, Mr. Conway. You are here for arraignment under cause number 6A0097605 and 6A. Oop, that's a different one. Sorry. You're here for 6A0097605 and 4A0299786. Mr. Conway is present. Mr. Haverco, I'll have you inquire.
What do you do? What do you think you're taking a look? Does random odd jobs. Last month he took home $1,200.
Okay. Mr. Conway, I'll find you're eligible for court-appointed counsel at no expense to you, and I will turn over to Mr. Haverco.
Stipulate to probable cause. As court to enter not guilty pleas on all matters.
Okay. All right, Mr. Conway, going to find probable cause for both the theft charge as well as the controlled substance, false statement, delivery, and loitering drug-related charge. Find probable cause for all 5 of those charges. Enter pleas of not guilty to each. And I'll turn over to the city for conditions of release. Okay. Mr. Conway, I'm looking at your record. You don't have anything, these are your first sort of flurry of charges. Has he been on warrant status for the theft charge? Okay. Mr. Conway, so this theft charge goes back to the summer of 2024. Why'd you miss court?
Showed up that day.
Okay. Okay. Are you back in town now? Yeah. Okay. All right. Then I'll I'll go along with the release conditions. Just noting Mr. Conway's failure to appear for a fairly significant period of time on that theft, but you're gonna be released on your own recognizance. Following conditions, you're to appear timely at all court hearings, not have any criminal law violations, keep your name and address up to speed with the court and DOL, not to go onto the property of Walmart. Is that gonna be an issue? Okay. Stay in touch with Mr. Haverco. Make sure, does he have a good number for you? Okay. And we'll see you back here on, date are we looking at? May 7th at 11? Next court date is going to be May 7th at 11 a.m. and you're going to be given a copy of this order. You can pick it up at the window, okay? All right, Mr. Conway, I've signed that order. You can pick it up at the window. Good luck. We'll see you back here May 7th. Next matter is City of Yelm versus Charles Doan. This is cause number 6A0010667. Mr. Doan is present out of custody, charged of driving with a suspended license third on operating motor vehicle without ignition interlock. Mr. Haverco, I'll have you inquire.
I represented him recently.
Okay. All right, I will reappoint Mr. Haverco for these new charges. And I'll turn it over to you.
Stipulates probable cause as to enter not guilty plea.
Okay. Mr. Doan, based on statements of counsel, I'm going to find probable cause for purposes of this hearing only and enter pleas of not guilty on your behalf. Hear from the city in terms of conditions of release. Okay. So, Mr. Doan has a DWS second from 2024.
I represented him recently on a suspended second, and city, his suspended status had gone down to third degree, so the city had amended to.
Yeah. All right. So, Mr. Doan, you've got some licensing issues. And if you keep driving, at some point, you're going to leave me no choice but to take you in, which would be kind of ridiculous on driving issues, but at some point I won't have a choice. So what I'm going to do is I'm going to release you on your own recognizance under the following conditions. You're to appear timely at all court hearings, no criminal law violations, keep your address and phone number correct with the court and DOL, do not drive without a valid license and proof of liability insurance, and comply with all Department of Licensing ignition interlock requirements. Okay? Next court date is going to be May 7th at 10 a.m. Mr. Haverco is appointed. You've worked with him before, so make sure he has a good number for you if it's changed. And you'll get a copy of this order at the window. We'll see you back here on May 7th, okay? Yeah, with me or with Mr. Haverco?
I'm not trying to push the border.
Oh, no. I'm not, I'm just saying, yeah. I got you. All right. Well, good luck to you and we'll see you back here on the 7th. Okay. We'll call you. All right. Next case is City versus Mike Fox. And I've got a note here, request for reset. So there's a request to reset this. It's a DWS third. Says he has jury duty in Tacoma. So it's a DWS third. What would this?
City would like to amend and provide notice. That way we don't have.
Okay. Okay. Yep. So what we'll do, is we'll amend to the Noval with ID $150 penalty, and then we'll send that to Mr. Fox and he can do with it what he wants. Do I need to sign that order? Okay. Okay. All right. Next matter is City versus David. Oh, we already dealt with that one. Sorry. City versus Riley Gould. Riley Gould. All right, good afternoon, Mr. Gould. You are here. Customer 6A00106669. Allegation is failure to transfer title within 45 days. Mr. Gould, in those kind of criminal matters, the city will make a motion to amend to expired tabs with a penalty of with a $150 penalty. Is that something you want to take advantage of? Okay. We'll have the clerk will do an order. Transfer the title. Okay. Get it taken care of. All right. And I'll sign that order. And again, you'll go out to as soon as I sign this, you'll go out to the window. You'll be getting a copy of the order and how to get everything taken care of. Okay. Thank you. Okay. Next matter, City of Yelm versus Courtney Hebert. Is it pronounced Hebert? Okay, good afternoon, Ms. Hebert. This is customer 6A00097606. Ms. Hebert is present, out of custody. Mr. Haverko, I'll have you inquire.
Takes home about 3,000 a month.
Okay. All right, Ms. Hebert, I will find you eligible for court-appointed counsel at no expense to yourself. Turn over to you, Mr. Haverko.
Stipulate to probable cause as court to enter not guilty plea.
Okay. I will hear from the city in turn, or Ms. Hebert, what I'm going to do is find probable cause purposes hearing only, going to enter a plea of not guilty on your behalf. Hear from the city in terms of conditions.
Standard conditions, yeah.
Okay. All right, Ms. Hebert, I'm going to release you on your own recognizance at this point. On the following conditions. You are not to commit any criminal law or criminal traffic violations. You are to keep your name and address current with the court and Department of Licensing. So, Ms. Hebert, there's this other individual, Zoe. That person still residing? Are you residing? They gone? Okay. Do you have any reason to have any contact with them? Okay, all right. Well, based on that, I won't do a formal no contact on that, but you've given information. I've appointed Mr. Haverko. Your next court date is going to be May 7th at 10 a.m. Stay in touch with Mr. Haverko. Make sure he has a good number for you, okay? Okay. We'll see you back here on May 7th. All right. City of Yelm versus James Kavanaugh. This is driving with suspended license. Third charge. Is the city making the motion? Okay, go ahead and amend this to the NVOL with ID, $150 penalty for James Kavanaugh. Next matter, Mike, City of Leon versus Michael Layden. It's cause number 5805829-2R. Charges DUI. Mr. Layden is not present in the courtroom or no one responding to that name. Anybody on Zoom? Okay. Um, Mr. Layden has a DUI from, okay, this is a, what are we dealing with? So I show, okay, do we, how did we get notice to Mr. Layden? Okay. Um, okay, let's mail notice one more time to the address for DOL. And if it doesn't get returned and he doesn't show, we'll be looking at a $5,000 cash or bond, but we'll hold that for now. Note is non-appearance. City of Yelm versus Felicia Lewis. Good afternoon, Ms. Lewis. This is cause number 6A0097607. Ms. Lewis is present out of custody. Mr. Haverco, if you could inquire.
What kind of information do you have? She's currently on TANF.
Okay, all right. I'll find Ms. Lewis is eligible for court-appointed counsel at no expense to her. And turn over to you, Mr. Haverco.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Okay. All right, Ms. Lewis, based on statements of counsel, we're going to find probable cause for this hearing only and enter a plea of not guilty. Hear from the city in terms of conditions of release. Okay. All right, Ms. Lewis, we're going to release you on your own recognizance under the following conditions. You're to appear timely at all court hearings. You're not to have any criminal law violations. You keep your address and phone number correct with the DOL and the court, and stay in touch with Mr. Haverco. Okay. Next court date is going to be,
And I'll be calling you about a week later.
oh,
Yep.
okay. Next court date's May 7th at 10 a.m. All right, I've signed that order. Next matter, City of Yelm versus Casey Little. All right, Mr. Little, this is a charge of driving with suspended license, third degree. What the city does in these circumstances is amend, if the city is going to amend, is that correct? Okay, the city's making a motion to amend this to a no valid operating license with ID, $150 penalty. Is that what you want to do? Okay. Do you know what you need to do to get your license back? What do you think you need to do? Good, okay. All right, I will sign that order and you'll get a copy of it at the window. All right, next matter, City of Yelm versus Sabrina Mankins. So it's cause number 6A0006661. Ms. Mankins is present, out of custody. Mr. Haverko, I'll have you inquire.
Disability, $1,000 a month.
Okay, I'll find Ms. Mankins eligible for court-appointed counsel at no cost to herself. Turn it over to you.
Stipulate probable cause, ask the court to enter not guilty plea.
Okay. Find probable cause for petition only, enter plea of not guilty, conditions of release. All right, standard conditions. Ms. Mankins, you're gonna be released on your own recognizance under the following conditions. Not to commit any criminal law or criminal traffic violations. Maintain contact with Mr. Haverko, keep your address and phone number up to speed with us and the DOL, not to have any contact with Walmart, okay? And timely appear at all court hearings. Next court date's gonna be May 7th, 2026 at 11 a.m. There's not, because we're pretty booked, but you can appear via Zoom. But I'll have you talk to Mr. Haverko. You got to get permission from the court to do that. So talk to Mr. Haverko. He can arrange that.
And I'll be contacting you. I'll be preparing your court date. Yeah, just ask the court ahead of time. You have to get permission. You can call, send an email.
Okay.
Yeah.
All right. Good luck to you. Next, and the copy of the order will be at the window to the right. Next matter, City of Yelm versus Damian Martinez Pisano. No response. Next matter is City of Yelm versus Gustavo Esteban Mendoza. Good afternoon. This is cause number 6A0041286. Mr. Mendoza is present, out of custody. Mr. Haverko.
This makes a few $100s a month.
All right, I'll find you eligible for court-appointed counsel at no expense to you. Turn over to you, Mr. Haverko.
Stipulate probable cause, ask the court to enter not guilty plea.
Okay, find probable cause for purposes hearing only, if enter pleas of not guilty to both counts of assault. Turn to the city for conditions of release.
Standard conditions, no contacts with the.
I need a phone number.
All right, so, does, Mr. Mendoza live at the 301 Jefferson Avenue Northeast address? And is that with Sam? Sam Mendoza? As well as, Marcelino? And Marcelino lives there. Those are the two so the two victims of this is a DV case. Two victims live in the same house as the defendant.
Can you live anywhere else? What's your situation?
Yeah.
Where are they? Here? Can live with his aunt?
Who is the victim in the SOC? Actually, wait a second. The SOC was a reckless burning, never mind. Mr. Mendoza, I'm willing to release you on an order of cognizance, but you're not to have any contact with Sam Mendoza or Marcelino Mendoza. So that means you're not to, if they reside at the 301 Jefferson Avenue Northeast address, you can't live there while this case is pending. Do you understand that? Okay, so does the, want to do a separate no contact order for it, or you want to make it just part of the? Okay, so if we can add that, it's Sam Mendoza. And then Marcelino, Marcelino. Mendoza. And he's not to go to the property, the 301 Jefferson Avenue Northeast. And you can mark a civil standby if he needs a civil standby to get some of his stuff. And what's the city want to do with the, okay. Okay. Are you adding that to the thing? Okay. Yeah, it's not propagating yet.
Is this important? Yeah. Is it? It's not important years right now.
Oh, there we go. Okay. Well, I got the court date, but it didn't say anything else. And it looks like, Mr. Africo, it looks like Mr. Mendoza, looks like he's re-engaged in some treatment through his quality. Okay. So we're going to reset this for May 7th at 11 a.m. But Mr. Havrico, if Mr. Mendoza is in treatment and if the victims reach out to you or talk to you and they want to change this, we can squeeze it in before then. But just in the interim, till we get some stability here, we're gonna leave it like this, okay? But you can always bring it back in sooner if you want to, okay? That makes sense, Mr. Mendoza? Okay. And then we're gonna set all matters for May 7th, 2026 at 11 a.m. You'll be given a copy of this order, and we do have a process for a civil standby. If there's some clothes or things you need to get from your house, you can contact the police department. They'll escort you there to get them, and then that they'll be able to get what you need to get. Okay. All right. I'll go ahead and sign this order. And you'll grab a copy at the window. Okay. All right. Good luck to you. All right. City of Yelm versus Christopher Morales. No response. City of Yelm versus Trevor Molka. Trevor Molka. No response. Next matter, City of Yelm versus Sharon Nay. All right, this is a DWS third, Mr. Bradfield, okay. All right, City of Yelm versus Sharon Nay. City's moving to amend to a no vol with ID, $150. Next matter, City of Yelm versus Alicia Olashea. All right, Ms. Olashea is present, out of custody. This is cause number 6A00219978. Mr. Haverko.
So I assume she just works part-time. She says she takes home about $300 a month.
$300 a month?
Yeah.
All right. Okay, Ms. Olashea, based on those statements, I'll find you eligible for court-appointed counsel at no expense to you, and I'll turn it over to Mr. Haverko.
Stipulate probable cause as court to enter not guilty plea.
All right. Find probable cause for purposes of this hearing only and enter a plea of not guilty to one count of theft third degree. Conditions of release from the city. Okay. Ms. Olashea, we're going to release you on your own recognizance. We're going to appoint Mr. Haverko for your as your attorney. You're not to go back to Walmart while this is pending. Do you understand that? You're not to go back to Walmart while this is pending. And maintain law-abiding behavior, no criminal law violations. And we'll see you back here on May 7th at 10 a.m. All right?
Where you go? Right here. Where you go? We'll call you before court.
All right, next matter, City of Yelm versus Kevin O'Leary. This is cause number 6A00106668. Mr. O'Leary is present, out of custody. Mr. Haverko, I'll have you inquire.
Takes home about $3,000 a month working as a part-time electrician.
Okay. Any dependents?
Lives with mom. He pays $375 a month of child support.
Okay, all right, I'll find Mr. O'Leary's eligible for court-appointed counsel at no expense to him. I'll turn it over to you.
Stipulate to probable cause as court to enter not guilty plea.
Okay. All right, Mr. O'Leary, we're going to find probable cause purposes hearing only, and we're going to enter a plea of not guilty on your behalf here for the city in terms of conditions of release. All right, Mr. O'Leary, you have a prior DUI amended to a reckless driving back in 2022. So I'm going to release you on your own recognizance under the following conditions. You are to not commit any criminal law or criminal traffic violations. You're to appear timely at all court hearings, not to consume any alcohol or non-prescribed drugs, not to drive without valid license and insurance. You are to not refuse a blood test or breath test if directed to do so from court, probation, or any treatment provider. You're not to possess any alcohol or any non-prescribed drugs. You're not to go to any bars or taverns. And also you are to have ignition interlock installed on any vehicle that you drive within 5 business days. Do you understand that? Okay. If you're not driving, you can file what's called an affidavit of non-driving, which Mr. Haverco and I have discussed. But if you are driving, you need to have ignition interlock in your vehicle within 5 days. Understood? Okay. You're going to be given contact on how to contact or information on how to contact Mr. Haverco. And be in touch with him sooner than later because obviously your penalties on this are much more significant than they were on the first one. So be in touch with him and keep this case moving forward. All right, you can have a copy at the window. Next case is City of Yelm versus Daniel Olson. No response. Next case, City of Yelm versus Shadrach Rimmerch. All right, Mr. Rimmerch, this is a driving with suspended license 3rd degree. If you were here earlier, you heard me advise folks in similar situations that what the city does is they amend this charge to a no valid operating license with ID and impose, which is an infraction, and they impose a $150 penalty. That's something you want to take advantage of. You can deal with it today. Right. Well, that's all how to get your license back. What the city's proposing is the city amends this charge to a no valid operating license with ID, and you pay $150 and it's your result. This issue is resolved. You still got to get your license back through the process. So is that what you want to do? Okay. So I'm going to sign an order and there'll be a copy of that order at the window. You can get that squared away. Okay. All right, City of Yelm versus Christina Russell.
Your Honor,
Yeah.
It's Daniel Olson, sitting right here. If she didn't hear you, Daniel Olson.
Okay.
That was number 29.
All right. Bring her, come on up. Is it Danielle? Danielle? All right. Let me get back to this one. All right, this is City of Yelm versus Danielle Olson. Cause number 6A00219777. Ms. Olson is present. Charge of driving with suspended license 3rd degree. So Ms. Olson, this is a case you are suspended in the 3rd degree. What the city does in these situations is they amend the charge to a no valid operating license with ID and impose a penalty of $150. It's an infraction. Is that what you want to do? Okay, I'll sign an order to that effect. You'll go out to the window and grab it and they'll be able to take care of you out there, okay? All right. Now, City of Yelm versus Christina Russell. No response. City of Yelm versus Zachariah Sawaya, or Zachary Sawaya, sorry. All right, Mr. Sawaya is present. Out of custody, cause number 6A00219775. Mr. Haverko.
Are you looking at it? Making $850 a month on unemployment.
Find him eligible for court-appointed counsel at no cost to him.
Stipulate probable cause, ask the court to enter not guilty, please.
Okay, find probable cause purposes of this hearing only as to both charges and enter pleas of not guilty. Hear from the condition or from the city in terms of conditions for release. All right, so I'm looking at Mr. Sawaya's history here. He has a protection order violation out of Puyallup, May of 2025. Violation of protection order out of Yelm, May 30th, 2025. Protection order violation, August 7th, 2025 out of Yelm. And then we have malicious mischief third, January 6th, 2026. And assault fourth degree, violation of harassment order, no contact order on February 27th of 2026. All right, I'll hear from you, Mr. Haverko, but I'm going to tell you, I'm inclined to take Mr. Sawaya, hold him on some bail. Because this is a theme developing in the last 8 months. So any thoughts?
What is the court?
Well, I'm inclined to impose $5,000 cash or bond here. Under the circumstances, there's multiple violations. I don't know if they're the same order, but they're the same sort of theme. We have a pending malicious mischief third in this court. So he's on conditions for that. So I'm inclined to impose a $5,000 cash or bond on this.
Just wanted to check. Wanted to see. Oh, it doesn't list. I was looking in jabs just to see if there was a theme as to the victim, but it's not always listed.
Right. I looked at that as well.
Well, I mean, what's it?
Well,
What do you want to say?
well, Thursday night, I wasn't there, so they just found that.
Are you in a situation where you're likely to have contact?
No, no, because he ended up moving into our house at 15499 Jen. So he's after the whole altercation that happened on Friday.
I moved into my dad's house all the way up in Puyallup.
Okay.
So I'm.
See your brother?
Yes, that's my older brother. So I'm currently not even living in Yelm anymore. I moved to Puyallup because he's been causing problems. So I'm currently.
Well, I guess I don't, there's no argument to redress the court's concern about the history because it is what it is. As far as the current matter, he advises he's, based on this conflict, I guess it's his brother. He's moved in with his dad in Puyallup. So at least for purposes of the pending matter, it would appear that circumstances help minimize any risk of public safety in this case. But again, I can't refute the court's concern about the history because it is what it is.
All right. So Mr. Sawaya, what I'm going to do is this. I'm going to hold you on $5,000 cash or bond. I think you are a risk to continue to commit crimes. I mean, again, I'm looking at your history, and again, since May of 2025, we have protection order violation, protection order violation, protection order violation. You have a pending malicious mischief from January of 2026 in Yelm that you were on conditions for. And then now, in a month and a half later, we have a new charge. And again, I realize they're just charges, but new charge of assault fourth degree and a violation of harassment, no contact order. So I'm going to hold you on $5,000 cash or bond. Do we think Mr. Sawaya is going to be able to post? Okay. If you post, or if you don't post, your next court date is going to be March 26th at 8:30 a.m. Again, I want you here, even if you post, I want you here at 8:30 a.m. on March 26th, and then we can deal with how to proceed with that. In the interim, if you do post, you're to appear timely at all court hearings. You're to have no criminal law violations. Keep your address and name and everything up to speed with Department of Licensing and the court. Not to have any contact with or go onto the property of Blake Sawaya, and you to abide by all no contact orders. Okay. Okay, so I'm going to turn you over to the custody of the officer, and then we'll see you back here on the 26th.
I'm waiting to sign the order. Oh, is this not, yours shows you're still in it? Please. Yeah. Same court administrator Dave Burnham is currently editing this document. No? I guess I could get out of it. And maybe it's, give me 1 second. I think it was frozen. Go ahead and sign on here. Okay, he's done. All right. I'll sign the order. All right. Okay, sign that order. All right, next matter, City of Yelm versus Osvaldo Simon. Osvaldo Simon is present, out of custody, charges DUI. This is again cause number 6A0006687. Mr. Haverko, I'll ask if you can inquire, please. He's just living with his brother. He's 20 years old and not working. Okay. Going to find you qualify for court-appointed counsel at no cost to you. So I'll turn over to you, Mr. Haverko. Stipulate probable cause, Your Honor, as the court to enter not guilty plea. All right, I'll do that. Enter plea, find probable cause for this hearing only. Enter plea of not guilty to 1 count of DUI. Hear from the city in terms of conditions of release.
Standard conditions?
Yes, sir.
All right. So Mr. Simon, I'm looking at this as your first offense. Okay. You're gonna be released on your own recognizance. I'm gonna appoint Mr. Haverco. You're gonna be released on the following conditions. And how, you're 20? No criminal law violations. Keep your name and address current with the court and DOL. You not to drive without valid license and proof of liability insurance. Not to drive or be in physical control of vehicle with any alcohol whatsoever. You have no alcohol-related offenses. You're not to refuse to submit to a breath test or blood test upon request of court, probation, or law enforcement. Not to use, possess, or you're not to use or possess any alcohol or non-prescribed drugs. You're not to enter any bars or taverns, which you're not allowed to do anyways because you're under 21. You understand those conditions? All right, you're going to be given information on how to contact Mr. Haverco. I expect you to contact Mr. Haverco sooner than later. You're going to be given information on how to contact him, and I want to make sure he has information on how to contact you. Any questions? Next court date is going to be May 7th at 11 a.m. And that is it. Grab a copy of the order at the window. We'll see you there. Next case, City of Yelm versus William Simpson. This is cause number 6Z0149012. Mr. Simpson is out of custody with Mr. Haverco. Mr. Haverco, I'll hear you, or I'll have you inquire.
Takes him about $1,000 a month on Social Security.
Yeah, I'll find him eligible for court-appointed counsel at no expense to himself.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty plea.
Okay, find probable cause, purpose of this hearing only, enter a plea of not guilty. So this is a no contact order violation. So the city's aware from 2016.
Oh, wow. So an old no contact order violation from March of 2016.
No, all right. So Mr. Simpson, this is a charge from March of 2016 involving Kimberly Eldred. And well, I'm just telling you what it was. So anyways, yeah, this is a matter from 2016. You've had minimal criminal history since that time. Just a couple of charges, nothing official. So based on that, the city's moving to dismiss. So you can be, I'm going to sign that order, and you can grab a copy of the window. Okay, good luck to you. Next matter is City of Yelm versus Savai Sock. No response. The City of Yelm versus Barbara Stewart Alley. No response. City of Yelm versus Louis Stroda. Mr. Stroda, is it Stroda? Mr. Stroda is present. This is cause number 680015697. Mr. Haverco.
Takes him about $2,300 a month.
Okay, find him eligible for court-appointed counsel at no expense to him. Turn it over to you, Mr. Haverco.
Stipulate to probable cause, ask court to enter not guilty plea.
All right, I'm going to find probable cause purposes hearing only, and we're going to enter a plea of not guilty on your behalf. Turn to the city in terms of conditions. All right, standard conditions, Mr. Stroda. Those conditions are gonna be law-abiding behavior. Maintain your address and phone number with DOL and the courts. No criminal law violations, obviously. Are you residing with Bradley Hendricks? You guys reside together? That- 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 And this happened back on March 1st. You were arrested, then released? Okay, and where have you been residing since that time? With Bradley? Okay. Been any issues since then? What's the city's thoughts? I mean, obviously, this is okay. Yeah, all right. What I'm gonna do is I'm gonna release you on your own cognizance, Mr. Stroda. I'm looking at your history. You don't have any similar history that I can see. But you're not to have any hostile contact with Bradley. I read the police reports, just you guys are getting heated, you walk away or he walks away or whatever, okay? So no hostile contact with Bradley Hendricks. All right, thank you. Any questions about that? And obviously, Mr. Stroda, the issue here is, I get it, maybe this is a one-time thing, but the problem is it developed into this. So next court date's gonna be May 7th at 11 a.m. Stay in contact with Mr. Haverco and make sure he has a good number for you. And then we'll see you back here on the 7th. And you'll get a copy of the order at the window. All right, next matter, City of Yelm versus Tiara Zolas. City of Yelm versus Michelle Tone. City of Yelm versus Orion Turnbull. Or what did I say? Orion Turnbull. All right. Good afternoon, Mr. Turnbull. This is cause number 680097610. Charges DUI. Mr. Turnbull is present. Mr. Haverco, I'll have you inquire.
In Oregon. Takes home about $6,400 a month. He's a sandblaster, currently working out of town in Oregon.
Okay. Based on what Mr. Turnbull makes, I will only, I'll appoint Mr. Haverco for just for the arraignment purposes, but not moving forward.
Already in discussion.
Okay. Mr. Haverco.
So for purposes of today, stipulate to probable cause, that's court general not guilty plea.
Okay. Find probable cause purposes hearing only. I'm going to enter a plea of not guilty. Looks like this is a first offense, Mr. Ratfield. Okay. Standard conditions, Mr. Turnbull, are you to appear timely at all court hearings? No criminal law violations. Keep your address and name and everything up to speed with the court and Department of Licensing. Not to drive without valid license and proof of liability insurance. No alcohol-related infractions. You are not to consume any alcohol or non-prescribed drugs. And you are not to go to bars or taverns while this is pending. Do you understand that? Okay. give a copy of this order. And when you retain counsel, just make sure they get a copy of it as well. Next court date is going to be May 7th at 9 a.m. And sign that order and you can grab a copy at the window. Thank you. Next matter is City of Yelm versus Brenton Vladica. Next matter is City of Yelm versus Brennan Wing. Mr. Wing is present, out of custody, cause number 6A00976602. Charges criminal trespass, second degree. Mr. Haverco, I'm going to go ahead and appoint you for purposes of arraignment because I know you represented Mr. Wing
Right.
before.
Pursuant to that, stipulate to probable cause, as the court enter not guilty plea.
Okay. So, Mr. Wing, I'm going to find probable cause for purposes of this hearing only, enter a plea of not guilty. So last time you were before me, we took you into custody. How many days in jail did you do? Okay. 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 So we have another charge of criminal trespass. No, don't yet. I'll let you talk to Mr. Haverco about that. So this looks like a different address than the typical ones. This is a 700 Prairie Park Lane. It's a Prairie Park Hotel. He was digging, digging through some smoking receptacles and things like that. All right. What's the city's thoughts on conditions of release? How are you doing, Mr. Wing? Okay. Well, I don't want you to talk about the facts. So do the same routine we did last time. I'm going to release you on your own recognizance today. We're going to set this out to whatever normal course, May 7th or whatever. You now know you're not supposed to go to this Prairie Hotel, right? And you know all the other places you're not supposed to go to. Just so you're aware, if you get another criminal trespass charge while this one's pending, either the officers are going to take you in, and I'm going to make a note on the record that there's going to be conditions like bail, or if you come back in and you show up here, which I do appreciate, you always show up, we're going to take you into custody if you got another charge. Okay, I mean, just so, because I remember last time it was kind of dramatic when you left, if you remember correctly. And I just want you to just understand, so you know what's going to happen if you do that. Right? Okay, so you're not surprised, you're not upset, you're not mad at me or mad at Mr. Haverco or upset at the police. If you just keep committing crimes, you're gonna get taken in. So I just want to make sure we're clear on that, because if it does happen in the next month or so, I'm going to say, Brandon, we talked about this. All right.
You still okay, it's okay, it's okay.
All right.
Yeah, and I'm always impressed that he shows up.
He's generally here.
Commend him for that.
Yeah.
I think that's being responsible.
So next court date, May 7th, 2026 at 10 a.m. Are you able to get a hold of him?
He doesn't have a phone, but, so, assuming he shows up for court next time, I'll just
Okay.
we'll talk to him then.
All right, no contact with the Prairie Park Hotel and law-abiding behavior. Okay, you'll get a copy at the window, Brandon. Thank you. Good luck to you. And then City of Yelm versus Jason Woodhull. Okay, this is driving with a suspended license, third degree. Is the city making a motion? Okay, city's motion will amend this to, driving with suspended or I'm sorry, no valid operating license with ID. Okay,
Folks in here that might all be here for civil.
we've got the infractions at 2:30.
Is anybody here for?
I think that was a DW's 3. Were you here for, so that's you're here for driving with a suspended license, third degree? Okay, what the city did is the city amended that charge to a no valid operating license with ID. And it's an infraction and imposes a $150 fine. So if that's what we did that, even though you weren't here, but now that you're here, if you want to do that, I can sign an order, you take it to the window and you can pay the $150. It'll show as a DWS third amended to an infraction, yes. And it won't have any effect on your ability to get relicensed. Okay. Yeah, it sounds like it. So you want me to sign an order? Okay, so I'm going to sign an order, Ms. Nye, to that effect. You can set up, but I think it's got to do $25 a month. Is it Nye or Knee? Okay. All right, I'm going to sign this order and you can grab a copy of the order at the window. Good luck to you. You raised your hand. Are you here? Were you here for a criminal case or infraction? Okay. All right. Okay. Mind if I take the infractions real quick, or do you guys need to get out? Okay. Can I take the infractions real quick, or you got to get out of here?
Well, I don't take the position of the
Right. Good point. Okay. All right. Okay. So we will call the infraction calendar. Start at the top. City of Yelm versus Timothy Flansburgh. Timothy Flansburgh, no response. Wait a second. Flansburgh. Oh, there it is. Okay. It's now 2:39. Calendar starts at 2:45. Anybody on Zoom? Okay. Go ahead and find Mr. Flansburgh's NVOL with ID committed. Do I need to sign anything with that? Destiny Hernandez, City of Yelm, come forward. All right, good afternoon, Ms. Hernandez. This is cause number 5A0754728. It's a mitigation hearing on no valid operating license with ID. Was this a DWS third that was amended in court? It was not. Okay, so this is a straight no valid operating license with ID. So Ms. Hernandez, you're here for the to mitigate this. And so what a mitigation hearing is that you're admitting you did it. You kind of want to explain the circumstances. So I'll hear anything you have to say. I'm going to have you speak up a little bit higher. Hey, could you close that door? I just can't hear. Okay. 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 So let me just look at something here. So you've got a permit, you've got a driving permit now. How old are you? Okay. And I'm looking at your, so you had a, no valid operating license without identification that was dismissed, Thurston County. Okay. What I'd be willing to do, Ms. Hernandez, based on the steps you've taken, I'd be willing to reduce it down to $100. The reason is because you've got this is not your first rodeo, so to speak. So I'll give you a break because you're doing what you can economically to get this taken care of, but I'll reduce it down to a penalty of $100. Okay? All right, do I need to sign that order or anything? Okay. Okay. So Ms. Hernandez, I'm going to sign an order and then you're going to go out those doors to the right. And then you'll get a copy of the order and how to make the payments. Okay? All right. Good luck to you. Thank you. Okay, that one's done. This one is there, Nicholas Hodge. Ready, Nicholas Hodge. It's now 2:42. Mr. Hodge was given notice to be here at 2:30 today. Mr. Hodge has failed to appear, so find the matter committed. And do I need to sign anything on those? Okay. All right. Okay. All right, why don't we go ahead and pull them up? Is it Ranella?
Good afternoon, Your Honor.
Hey, good afternoon, Mr. Scow. How are you?
Life is good.
Good. All right, you are here on City of Yelm versus Lincoln Kekua?
Yes, Your Honor.
Cause number 5807508666. We have two infractions. One is a speeding 23 over, as well as a no insurance ticket.
Yes, Your Honor, and last time I was before the court, we continued this so we could inquire of Mr. Kukuo about his insurance status. Unfortunately, he has not been responding to our attempts to get that information from him. So as to count 2, I'll just be asking the court to mitigate that count today based on the fact that this is his only no insurance charge on his record. And I do have some arguments as to count 1 when the court's ready.
I'll listen to well, on the first matter, on the no insurance ticket, looks like this is his first one that I can see. So I'll mitigate it down from 564 down to 250.
Thank you, Your Honor.
I'll hear your arguments on the speeding ticket.
Yes, Your Honor, as to count 1 speeding, there are some deficiencies in the officer's narrative that I would like to bring the court's attention to. Namely, the officer doesn't tell us who was operating the speed measuring device, the radar in this case. He says, quote, the operator was absolutely certain the radar was indicating the defendant's speed. This is an interest because he's been writing in the first person up to this point, and suddenly he's referring to someone else as operating the radar, and we don't know who that person is. Additionally, when he's talking about when that radar unit was checked and calibrated, he says the unit was checked. He's using the passive voice throughout all of that. He doesn't tell us who is testing the device or whether or not he has any personal knowledge of that testing. So I don't know. It's messy enough that I don't think we can reasonably assume that the officer who wrote the report is the same person who tested the device or used the device on the date in question. So we would move to suppress speed and dismiss.
Okay. Based on that, I will press the results of the speed measuring device and grant your motion to dismiss the speeding ticket.
Thank you very much, Your Honor. And I believe that's the only matter I have before you today.
Okay, I will sign an order to that effect.
Thank you very much and have a good rest of your day.
You too. Do I sign an order to that effect? Yeah, there we go. Okay. 250 and then. Got it. Okay. All right. And then let's see. How about Rebecca Richards? Good afternoon, Miss Richards. This is cause number 580754721. Ms. Richards is present for mitigation of a traffic infraction, no valid operating license with valid ID and no insurance. So Ms. Richards, in this situation, as I said before, this is you admit to the allegations, you just like to explain the circumstances. So let's deal with the no insurance ticket first. What would you like me to consider on that? Did you have insurance on the day in question?
No.
Okay, do you have insurance now? Okay. 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 I'm obviously very sorry to hear about your husband. Let me just look. Do you have any prior no insurance tickets? Yeah. Technically, you have one from 2008. Yeah. Operating motor vehicle without ignition, without insurance from Thurston County, September of 2008. Anyways, that's a long time ago. All right. You certainly hadn't had anything in 15 years. So what I'm going to do with the no insurance ticket is I'm knock that down to from 564 down to 125 bucks. And on the no valid operating license with ID, you sounds like you know what you need to do to get your license back. Okay. What I'm going to do is I'll knock that down to from 564 to 150. So, okay. It's not making it go away, but it's giving you a little bit of a break. Okay, and then I'm going to sign an order and you can pick up a copy of that order at the window. Thank you. Let's see. Okay. Sign that order. Okay. Steve Rawlings. Good afternoon. How are you? Good. Okay. Well, Mr. Rawlings, here on cause number 580912242, operating motor vehicle without current proper registration and plate, and then failure to wear a safety belt. Okay. Okay, hold on one second. Let me look at something here. Right. Well, what we could do is this. You are eligible for deferral if you wanted to. What's the deferral on that? It'd be what, 150? 100, okay. 4-month deferral, and you can do both of them. So you could do a deferral on these. These are non-movings too, I believe. Yeah, but they're non-moving infractions. So what we could do is to keep, if you're interested in keep off a record, and basically it'd be $100 for both total, and you would be a deferral. You get one deferral every 7 years for one, a non-moving and a moving. These are non-movings, I believe.
That's not gonna affect my deferral that I'm looking for you like Thurston County.
No,
Okay.
no.
As long as it don't affect that, then I got a problem.
Yeah, well, I'm not sure you, I appreciate you calling me dude, but that's okay. That's okay. Let me let me make sure, what have you got going in Thurston County? You've got a,
I got a DUI pending.
okay, you do,
But it
okay.
happened in 2024, and I'm already going for this, first, I'm hoping for a second deferred on
Okay.
DUI, which just became law as of 2024.
Yeah. So, yeah, these two infractions would not have any adverse effect on what you have going in Thurston County. Okay. So $100 deferral, 4 months. Okay. Okay, I'll sign that order and you can grab a copy at the window. Thank you. Thanks for your patience today. Yep, you too. All right, and then we have one more. Garrett Weed.
Good afternoon.
Afternoon, Mr. Robbins. How are you?
Good. How are you doing today?
Good. You here on the Garrett Weed matter?
Yes, Your Honor.
Right. This is cause number 5A09329661. I will advise you ahead of time, Mr. Weed is eligible for a deferral if he's interested, or if you are interested on his behalf.
Your Honor, we would prefer to argue. Thank you.
Okay. All right, go ahead.
It's an argument to dismiss any evidence of speed for lack of foundation. The officer here doesn't say whether or not he used the turning forks by striking them on a metallic surface. I understand that he says he used them, but I don't know if he used them in a way that would, show the accuracy of the device.
Okay, let me take a look. Okay, I will agree based on the police report's devoid of indication that he was using it consistent with training. So based on that, I will grant your motion to suppress and go ahead and dismiss the infraction that's pending for Mr. Weed.
Thank you, Your Honor. Have a great afternoon.
Okay, you too. Okay. Once. All right, first one would be Ryan Averill. F3rd 500 cash or bond. We dealt with True Buried. That's it. Or no, we did not. True Variance. We did. That's the DWS3 that was amended, right? Okay. Next one would be Damian Martinez Pisano. It is a charge of use of drug, paraphernalia, controlled substance, no in possession. Martinez Pisano.
Oh, Martinez.
250 cash or bond on each. Christopher Morales, theft 3rd degree. 500 cash or bond. Trevor Molka. Oh, okay, we dealt with it. Okay. Christina Russell, controlled substance, no in possession. 500 cash or bond. Survey Sock. Controlled substance, use of drug paraphernalia.
250.
250 each. Barbara Stewart Alley. DWS 3rd and no ignition at all.
500 each.
500 each. Tiara Zolas. F3rd, use of drug paraphernalia, controlled substance, no in possession.
250 each.
So 1,000 total. There's actually 4 counts.
Yeah.
250 each. Michelle Tone, UWS third, that was amended, I believe. We dealt with Orion Turnbull. Brenton Vladika. Controlled substance, knowing possession, use, delivery, drug paraphernalia, loitering. 250 each for 750 total. Okay.